Yes, Mr. Bora.
I seek permission to move an urgent matter, tender
What
matter.
is the urgency?
Lordship, is a supply matter. I was the L1. But I have given 20% of the supply and rest to L2 and L3. 30 December is the last date to complete the supply. Therefore,
Lordship, we filed an affidavit of opposition.
Wait, please, your lordship. In item number 21, it was listed yesterday. Yes, I filed the IE, your lordship. So I may be allowed to bring that on record.
Give a mention memo, it will come up in the production list. IA, no?
IA,
It's an IA.
IA. But
It has to come up in the production list, no? It's an IA after all.
Item number 26. Yes, infections. Yes, already infections. Payment will be done.
What?
Item number 26.
Item number? What is that?
Payment will be done.
You want to withdraw? You want to withdraw? Yes, Mr. Gogoi. What is this item? Item 26. He says that the payment has been done.
Non-payment. Non-payment, yes.
Huh?
If he has got it, my lord, it's non-payment of contractual bill.
You have got it. So nothing remains.
No.
Mr. What's your name? Huh?
R.I. Mandal.
Mr. R.I. Mondal, the learned counsel appearing on behalf of the petitioner, submits that he have already received the dues for which the instant writ petition was filed. Mr. B. Gogoi appears on behalf of the health as well as the NRHM. Appears on behalf of all the respondents.
All the response.
So taking into account the above, the instant writ petition therefore stands closed.
I did mention item number 5. I want to withdraw my document.
Withdraw. Name?
Yes, Ahmed.
Mr. S. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the writ petition. Taking into account the above, the writ petition stands closed on withdrawal.
May I please, your lordship? I beg to mention item number 3, lordship. I am 3. I am praying for adjournment, lordship. Day before yesterday, they served the copy, lordship. So I need some time for instruction, lordship.
Wait. We'll take it up. You are in a hurry to go somewhere. No, don't go. We'll take it up. Anybody, any more mention? What is it?
Yesterday, I have planned one IA for listing. Your lordship was allowed, but unfortunately, it could not list it. It's because it's no correction of order.
Correction?
Yes.
Okay.
No, administrative approval election board.
Here. কি হয়? Mention করেছেন? I will find.
It's regarding non-payment of contractual bill. Lordship has directed me to have the instruction. My lord, here I have sought for instruction from the chief engineer's office as well as the executive engineer, PWD. It relates to health department. Work has been completed. Amount, my lord, lordship is directed to re-verify and whatever is due is to be paid. But it is of 2021. The administrative approval in the meantime has got lapsed. So, my lord, I will place the entire clear picture, let it be on 5th or 6th. My lord, they are seeking for some time. What proposal has been mooted, everything I will place. Thereafter, lordship may pass a, my lord, order. But it will ultimately, health will have to make the payment. Health and Family Welfare Department.
Health is a party.
It's a party, my lord, but then it will have to move, it will have to be mooted through the, my lord, PWD amount and all. I will place everything, my lord, let it be on 5th.
Whatever may be, there is a direction being given.
I understand, my lord. On 5th or 6th, my lord, or 7th. Let it be on 7th. my lord.
Mr. B. Gogoi, the learned additional AG, who also appears on behalf of the PWD, Finance, as well as the NHRM. Sa-
No, health. NHM has nothing to do, they have clarified. It is the Health and Family Welfare, my lord, will have to
as
take
well
that
as the
forward.
Health and Family Welfare Department submits that the three departments are looking into the aspect as to how the compliance to the order dated 26/3/2025 passed in WPC number 901/2024 can be affected. He therefore submits some more time is required in that regard. List this matter on 28/1/2026. In the meantime, the Mr. B. Gogoi shall ask the respective departments to do the needful and provide a update in that regard.
My lord. No less.
Ishari, what is this matter about?
My lord, petitioners, they are claiming, my lord, they are fishermen, my lord, of their locality. And they are claiming, my lord, some government fisheries, my lord, to declare public, my lord. They want to do fishing jobs there, my lord. And as per them, my lord, the Gao Panchayat secretary and president of that area, my lord, illegally occupied that government fishery and give it to someone else, my lord. This is their allegation.
Okay, none petitioner has not appeared.
Yes,
So
on the last day also, my lord, on the very first day, they took time, my lord. After vacation, maybe. my-
none appears on behalf of the petitioner when the matter is taken up, considering the above, Mr. S. Dutta appears on behalf of the PNRD department. Considering the above, list the matter after vacation.
I love this.
What is this? Did you provide him the copy?
Yes,
When?
day before yesterday.
Then? You are not in urgency. This court passed an order on 16/12/2025 to provide a copy to Mr. G. Sharma, the Learned Standing Counsel, who appears on behalf of the Foreigners Tribunal, as well as the SP Border.
Yes, lord.
However, the copy was not served as directed. Rather, it was only served day before আজি কি তাৰিখ? 17/12/2025. Considering the above, the above act on the part of the petitioner therefore shows that the petitioner does not have any urgency. Considering the above, leaves the matter after vacation. In the meantime, Mr. G. Sharma shall obtain the necessary.
Yes, yes, no problem.
Yes, Mr. Nath.
My lord. The petitioner was, my lord, the contractor for transportation of goods. Transportation of rice in state of Haryana. He was appointed for period 1 year, 2019-2020 financial year. After completion of 1 year, they given various extensions, my lord. Now the extension continues till 31st of December of this month, my lord. Meanwhile, in between, the petitioner wrote to them that we are working very low rate. It's very difficult for us to run over it, my lord. So we'll not.
No,
continue
no,
the
no,
work.
no. Let us come to the point. A notice inviting tender was issued,
Yes,
page 43,
yes.
for carrying, unloading of allotted food grains in the rice mill.
Right.
Okay. Now, what has happened?
I have something-
Why you have been held to be technically not responsive?
No. It's a different page 65, please come, my lord.
Ah.
65. Page 65, serial number, minutes, this is it, minutes. Serial number 1. Committee decided to cancel Universal Agency due to mid-term resignation from carrying contractor for the financial year 24-25. This is what I said. This is not correct, my lord. This is not correct. We have not resigned. We are continuing. They given us various extensions. Our extension will continue till 31st of this.
So you have a valid trade license?
Yes, we have got it. Yes, we have got it. There is no issue about problem. That we have got. There we come, please come to page number 40, my lord. 40. There the representation we have given, and they forward on that representation. Page 40 and 41.
Hmm.
8th of February, we have written to them, my lord. Although we have written, but we never discontinue. We continue to work. And they've also given me extension, various extension, page 42.
No, you say that you will not be able to extend or continue
Yes, for
the work beyond the expiry period
There period was, my lord, that previous paper, my lord, kindly.
on 31/3.
Yes, that will be in page number 30.
So you continued till 31/3.
31 they continued. 31 they continued. Thereafter, they also gave me one page 42. Various extension, page 42 kind of. In pursuance of the government letter number such and such, government of Assam, authorities shall be along from the please to order for lifting, my lord. I am in seal number 2 universal.
It is being again given to you.
My lord,
It is being given to you again.
again, extension. Till it was initially for 1 year. In 2021, they are completed. Then from 20 to 25, 5 years, I am continuing extension. They are giving me extension. My extension continues till 31st of this month. It is there, my lord. So can you look at this page, my lord? Yes. Page 64. Page 64. 15th of this October, order was passed. Actually, never abandoned the work. Although I
So
have
you are
written-
still continuing.
Although I have written, my lord, it's true I have written, but I never discontinue. They have given me work also. Now, when I find the tender in the new submitted by tender pursuant to the new NIT, my lord, they have taken a plea, my lord. That no, you have discontinued. I never discontinued, my lord.
And is it one of the terms of the conditions?
No, page 46 kindly come. Page 46.
Hmm.
This is a discrimination ground. Page 46, bottom, seal number 4. Bidders who are blacklisted or debarred or any center such and such are not eligible. If the proprietor or any of the
You
partners,
say 4/3 is not applicable.
No, bidders whose contract. None of this applies. My lord. It is something, my lord, the
Yes.
blacklisting of department. it is.
Yes, Mr.
My lord, earlier the petitioner wrote that he will not continue at the rate, at the prevailing rate, my lord. Now his technical bid was rejected thereafter in the month of, my lord, August, my lord. Now the financial bid was open and contract was awarded in the, my lord, 25th November, page 68, my lord. At that time, my lord, petitioner did not come, my lord, that the 5/8/2023, 25/8/2023, his technical bid was rejected, my lord. And thereafter, when the financial bid was opened, my lord, and the contract was awarded, at that moment, my lord, the petitioner is coming before this court, my lord. As it is a supply of the food grains, my lord, so the, my lord, as the tender process has not been continuing, so they were allowed to, my lord, leave the, my lord, materials from the,
No, no,
Sector.
so your submission is the reason may be bad,
my lord.
but why should this court interfere?
My lord. And the petitioner himself,
Why
my
it
lord, that
comes
he
so
is
late?
not able to continue at that, by page 67. Page 67, he wrote to us that while we had submitted request for withdrawal citing financial non-viability. Petitioner himself wrote to us.
No, I'm saying we have never done the work. This is my
Thereafter, he was continuing, my lord.
Technical bid.
And now the
No,
rate,
all
my lord.
things are understood, but Mr. Nath, the problem is, why should this court interfere? Why, when you have come so late?
My lord, on 25th of August, my lord, they have opened the technical bid. It was not uploaded immediately. Paragraph 12 I have written. On 18/9/25, a detailed representation, page number 64, 66, my lord, kindly see. Detailed representation, not even 1 month. 18/9.
What?
Detailed representation. I
No,
read.
no, that you have, oh, it's okay. But after that 3 months, why?
No, not 3 months, my lord. Kindly see, 25, kindly see, page 65, 25/8/25.
Mr. Nath, kindly understand. 25/8/2025, they
Technical bid open.
wait, technical bid open, you were rejected. Let us assume you did not know.
Yes.
You came to know 1 day prior to 18/9 because it will take some time for you to make it. 1 day. It is 17/9. You submit your representation on 18/9.
Yes.
You approach this court now in the month of December.
My lord, wait, there's some reason behind it. When we filed it on.
Either it is a case where you don't trust this court, that coming to this court would not serve your purpose, or you, sir, thought that the last day being a last day of the year, the court would be more benevolent.
No.
Either of it. What do you say, Mr. Sudhir? Huh? Either of it must be the reason.
My lord, my
Huh?
lord. The
It
last-
cannot be otherwise to approach this court on the last day when everything is over.
My lord, kindly just.
Even the work order was issued in the month of November.
My lord.
20th November.
So,
20th November, my lord. Kindly see, my lord, represent.
or is it the case that you are sure the last day the court
Ma-
would not dismiss the result, forgive no stay, would not dismiss the writ petition?
So what this honorable court is concerned.
The
or it
court
should
may be-
strict, my lord, my lord.
The court may not have much time
lord,
today,
kindly see, my lord.
so they may like to rise early. So the court may not
Yes,
dismiss.
not only right, my lord, and I also wish your lord very, very happy holidays, my lord. There is no doubt about it, my lord.
So,
My lord, kindly consider.
I
my lord.
can't-
Then come forward with the representation, my lord. the
No,
reply.
you have a good case, but the problem is your case, you have come so late.
But my lord, when the representation is pending, they
And
were
the- my lord-
they received it, my lord. They are sitting over.
Earlier,
representation, my lord.
earlier the rate which was allotted, my lord, that was not, they wrote to us that it is not viable. Now the rate was reduced, my lord. On the reduced rate, my lord, contract was awarded. Earlier rate was, my lord, the petitioner rate was 85 rupees. Now the rate is, my lord, 65 rupees. That is also there, my lord. It is there, my lord.
You have enclosed, huh?
No,
It is there.
No, you have enclosed it.
Enclose it, my lord.
that one I have.
Enclose by
No,
page
you have
32.
enclosed this.
My lord, page 32, that universal Messrs. Hauragat at the rate of
Now,
85.
page 69.
Yes, my lord. Page 73, rates are there, my lord.
Page
Present rate, my lord.
Yeah.
That, my lord, Hauragat,
65.
page 73, lordship will look into it. Page
Was
73.
wrong, so and so.
Hauragat at the rate of 50.
On this ground, they have not rejected my tender, my lord.
That's my lord, on a merit, my lord, on merit, my lord. On merit.
They are sitting over the representation, my lord, all these days, my lord.
Hauraghat, my lord,
They are
at the rate of
voting
50.
by it only.
Earlier rate was 85, my lord.
They received it to the representation. They are sitting over the matter and the final order. It is the authority, my lord. They cannot compare with this.
Chalo, I
These are
think,
half of the rate, my lord.
what should I do? Dismiss?
At the vacation, my lord, notice may be issued, we'll take the, my lord.
No case.
No, this, my lord. Hello, After
No,
lordship, my lord,
you see, this is a big problem which is going to happen later
My lord.
on if I issue notice in
my
this
lord,
case.
my lord,
Unnecessary things.
my lord.
Tomorrow somebody will think that, look here, what is
Yes,
this?
notice has
They
already
should
been
have
issued,
been.
my lord,
Huh?
my lord, my lord.
I think we should cut it at the
My
root.
lord,
Root.
one-
He has a good case, but approaching this court late is the
After,
reason.
my lord, after finalization of the issuance of the, my lord, my lord,
Everything he
order, my lord.
knew, and now he has come. Even he knew about this finalization order in the month of November,
November, my lord.
and he has come in the month of
And my
December.
lord, the rates are, which were, my lord, allotted, my lord, it is a half of the earlier rate. Earlier, he wrote that he could not do the work at that rate.
Yes,
Now-
that is a good ground for dismissal.
That's the ground they have not challenged, my lord.
My lord,
But I want to say.
it appears from his record, my lord. It appears from the record, page 32, the petitioner annexed it, that the Hauraga yearly rate is, earlier rate is 84, now present rate is only 44.
What do you want, Mr. Nath? Saving yourself from embarrassment by withdrawing or by getting a dismissal on the last date? Whichever it is, you take it. Because these two keep up again out here. These are later on become thorns.
My
Now,
lord,
only
my lord.
one thing, my lord, my lord. Now you consider one point, the lordship must pass any order. I happily accept, my lord. Then what I always do, my lord.
No, Mr. Nath, there is no quarrel that you have a very good case in the technical bid rejection. But why should this court now take up this matter?
My lord.
You waited all this while. And it is not like a service matter where you issue a representation and then wait. Then also the Supreme Court says about Kumbhakarna. You are not even a Kumbhakarna. Kumbhakarna is better.
My lord, only one thing. The ground on which they rejected my.
Absolutely. I'm telling you, you have a very good case.
My lord, and the tender. At the same ground they take, my lord.
So, then you withdraw without prejudice. Without prejudice, that this ground, I can very well, while dismissing it, I will say that the ground was wrong. But then also, this court is not entertaining 226. Will be okay. Take either of it.
That because
Ah,
otherwise what happens? Next time when I submit a tender,
mm.
they will take this ground. They are arguing in the tender matter. He has abandoned the work. It becomes development for me.
So then I will observe that this is a wrong ground, but this court, in exercise of 226, would not like to entertain. Better, no? That's a face-saving order. Yeah, it is mildly negative, mostly positive. Heard Mr. M. Nath, the learned counsel appearing, senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr. J. Suthia, the learned standing counsel of the Karbi Anglong Autonomous Council, appears on behalf of the respondent numbers 3, 4, 5. And Mr. K. Gogoi appears on behalf of the respondent number 1 and 2. Full stop. The petitioner is aggrieved by the rejection of its technical bid as on the rejection of its technical bid in the minutes of the meeting held on 25/8/2025, and further the allotment, the granting of the contract to the private respondents. Full stop. The brief facts of the instant case are that the petitioner was awarded a contract for supply of for transportation of rice under NFSA 2013 within the Karbi Anglong Autonomous Council area for the financial year 2019-2020 for Tier 1 and Tier 2. Full stop. The petitioner continued to render his services against the said contract at the rates which were fixed. The respondent authorities, being satisfied, granted extension to the petitioners from time to time. Full stop. It is the further case of the petitioner that in the year 2025, it became unfeasible and unviable to carry out the work for handling and transportation of work of NFSA's food grains beyond 2000 in the year 2024. It became unfeasible. And under such circumstances, the petitioner, Mr. Nath, tell me one thing. Where is the receipt of this document at page 40? Have they received it?
They received it.
Because on 8/2/2025, you say that it is
No,
beyond feasible.
Yeah, not right. Below, I think should be 25. Below, it should be 25. I marked it, my lord. This is
Huh?
a mistake. There is
What market?
page 2040.
Ah.
Kindly see 8 to 25 and the last paragraph one, 31 to 24. It should be 25. It is a mistake. Yes. Correct. Mistake is the paragraph.
That in the year 2025, it became unfeasible and unviable for the petitioner to continue the contract of handling and transportation work of NFSA food grains in view of the rates, and as such, submitted a representation to the Principal Secretary, Karbi Anglong Autonomous Council, stating that the petitioner would not like the contract extended beyond 31/3/2024. Bracketed Debo. The learned senior counsel for the petitioner submits that it should have been 31/3/2025. Bracket close. Full stop. Be that as it may, the respondent authorities kept on extending the said contract. And from the materials on record, and more particularly, the communication dated 15/10/2025 issued by the Secretary FPD NCA Karbi Anglong Autonomous Council, it is seen that the petitioner's extension was granted up till December 2025. Full stop. In the backdrop of the above, it is now relevant to take note of that a notice inviting tender was issued on 1/7/2025 for carrying, loading, unloading of allotted food grains, that is rice under NFSA 2013 in two tier system. এইটো ইয়াত page 43 এইটো specification of work যোনটো আছে এইটো দি দিব. This work in question was that notice inviting tender was in for the period from 2025 to 2026. Full stop. The said notice inviting tender contained various clauses relevant to take note of. Clause 4 of the terms and conditions of the bid, as the same has relevance for the purpose of disposal of the instant writ petition. The said clause 4 relates to disqualification conditions for tender, and the same is reproduced hereinunder, page 46. The petitioner being interested in the said contract participated along with various other bidders. Full stop. To the surprise of the petitioner came to learn that the petitioner's bid was rejected solely on the ground, technical bid was rejected solely on the ground that during the midterm that the petitioner had submitted a midterm resignation for carrying contractor for the financial year 2024-25. This decision was taken in the minutes of the meeting dated 25/8/2025, which is being assailed in the instant proceedings. The petitioner, on coming to learn, submitted a representation on 18/9/2025 before the Secretary, Department of Food and Civil Supplies and Consumer Affairs, Karbi Anglong Autonomous Council, wherein it was categorically mentioned that a question of withdrawal, wherein it was mentioned that the alleged ground that the petitioner had left the work midterm cannot be a valid ground, inasmuch as the tender in question was initially awarded for the financial year 2019-20, and subsequently it was extended from time to time, and it was in fact extended till September 2025. Mr. Nath, I am now at the position of taking into account 18/9/2025. At that point of time, you did not know that it was till December.
Yes.
You came only on 15/10, isn't it? The said representation, however, was not considered. On the other hand, on 15/10/2025, there was a further extension being granted to the petitioner to handle and supply the food grains up to December 2025. Full stop. The petitioner was expecting, it is the case of the petitioner that the petitioner was expecting that the respondent authorities shall duly take note of the representation and thereupon remedy its mistake for rejection of the petitioner's technical bid. However, the petitioner came to learn that in the month of November 2025, an order has been passed whereby the contract has been awarded to various bidders. It is under such circumstances the petitioner has approached this court by filing the present writ petitions on 16/12/2025. This court have also heard Mr. J. Sutia, the learned standing counsel of the Karbi Anglong Autonomous Council. Mr. J. Sutia, the learned standing counsel, submitted that this is a contract pertaining to handling and transportation of food grains. And as such, food grains, full stop. The fact that the petitioner submitted before the respondent authorities that the petitioner was not able to further continue with the contract beyond 31/3/2025 is admitted. The reason being that the said contract was not financially viable. The learned counsel, standing counsel further submitted that the instant writ petition has not been found bona fide, inasmuch as the petitioner knew about the reasons for its cancellation, knew the reasons of its rejection of its technical bid. In the month of September 2025, as submitted by the learned senior counsel for the petitioner. But then also the petitioner have not challenged the same before this court. The learned standing counsel further submitted that on one hand, the petitioner had admitted that it was not financially viable at the rate of rupees 85 per metric ton.
My lord.
But the petitioner now have approached this court challenging that the petitioner should have been granted the contract when now the rate is rupees 65, which would be more financially not viable for the petitioner. The learned senior standing counsel submits that taking into account that the petitioner is currently running the
it was-
carrying out the contract for handling and transportation on extension basis. Any delay by passing of interim directions would aid the petitioner in for getting a further extension. Anything more?
My lord, rate is, my lord, wrong. Earlier rate, he was quoted, my lord, for Hauraga nearly 84, now it is 45. Lordship mentioned it 85 and 65.
85 and 44. 84 and 44.
45, my lord. My lord,
85,
in the technical bit,
80,
petitioner,
84 and 44.
45.
45.
And the petitioner technique, when at the, as per the contract, terms of contract, petitioner is required to be present at the opening of the technical bid, my lord. So when he was present in the opening of the technical bid, he knows about it, my lord, his rejection.
The learned counsel standing counsel further submitted. No, obviously in the minutes you are not there.
Number in the
No, you rejected it on the minutes because
My lord.
let us not go into that question
lord,
again
my
because
lord.
of the fact that your tender categorically says,
65, my lord.
where is the page? Yeah, the tender opening date is, technical bid opening is 24/7.
My lord.
And you decided minus was on 25/7. Then how do you say that? Don't make that. I think this is enough for
My lord, my lord. My lord.
demolishing the case of the.
My lord. My lord. Must
Okay.
be.
This court have heard the learned counsels appearing on behalf of the parties and perused the materials on record. First. From the above quoted, full stop, this, yeah, full stop. Clause 4 of the terms and conditions of the notice inviting tender dated 1/7/2025 have already been reproduced in the foregoing sections of the foregoing segment of the instant judgment. The various grounds for disqualification are either the bidder is blacklisted or debarred, or the proprietor or any partner of the firm or any director of the company have been convicted by a court of an offense and sentenced to imprisonment for a period of 3 years or more, or when a bidder whose contract with the FCI or any department, public sector undertaking, had been terminated before the expiry of the contract period at any point of time during the last 5 years, or information in litigation history in which the bidder is involved. In the backdrop of the above, if this court duly takes note of the materials on record, it is seen that the petitioner was awarded the contract for transportation of rice under NFSA within Karbi Anglong Autonomous Area for the financial year 2019-20 for Tier 1 and Tier 2 by an order dated 27/9/2019. The said contract was for a period of 1 year. The said contract thereupon, at the request of the petitioner, was extended from time to time. Full stop. There is nothing on record that the petitioner's contract was at any point of time cancelled, terminated. In fact, the materials on record show that up till December 2025, the petitioner have been permitted to carry on that contract. Full stop. Therefore, the rejection of the petitioner's technical bid by the impugned minutes of the meeting dated 25/8/2025 for the reasons cited in the impugned minutes of the meeting dated so and so do not appear to be in accordance with the terms and conditions of the notice inviting tender. Further to that, it is also seen that even till date, the petitioner still is carrying on providing the services on the basis of the extended contract. Full stop. Be it as it may, this is also very pertinent to take note of. That a perusal of the order dated 27/9/2019, which is Annexure 3 to the writ petition, categorically mentions the area where the petitioner is required to carry out the handling and transportation of the rice under the NFSA, and also stipulates the rates per quintal which the petitioner would be entitled to against such work. From a perusal of the statement enclosed to the order dated 27/9/2019, it is seen that the rates which were granted to the petitioner ranged between rupees 79 to 85. Full stop. It is an admitted position. The petitioner have duly admitted in his communication dated 8/2/2025 that it is not viable and feasible for the petitioner to continue to supply at the rate at which the petitioner was granted the contract by the order dated 27/9/2019. This aspect is also it is also apparent from the representation submitted by the petitioner on 18/9/2025, wherein it is mentioned by the petitioner that the petitioner submitted the request for withdrawal citing financial non-viability First, this court duly takes note of that although the technical rejection of the petitioner was not proper, but the rates at which the contract has been awarded to the respondent number 6 to 8 are much below the rate at which the petitioner was granted the contract on 27/9/2019, wherein the petitioner stated that it was not financially viable to carry out the contract. First, now the question therefore arises that under such circumstances, should this court exercise the powers under Articles 2 to 6 of the Constitution? First, it is the opinion of this court that the powers under Article 2 to 6 of the Constitution are to be exercised 2 to 6 of the Constitution. First, this court is of the opinion that this is not a fit case for exercise of powers under Article 2 to 6 of the Constitution. The reasons being, number one, the petitioner knew very well that its technical bid was rejected on 25/8/2025, or at best, some days prior to the representation dated 18/9/2025. The petitioner waited all this while and have approached this court by filing the writ petition on 16/12/2025. First, in the opinion of this court, the inaction on the part of the petitioner to approach this court immediately had become fatal for the petitioner, for which this court would not like to exercise its equitable jurisdiction in the present facts. Number two, it is the very case of the petitioner that the petitioner's bid was never the contract was never terminated or cancelled. But the petitioner wanted that there should not be any extension beyond 31/3/2025. The reason being that it was not financially viable for the petitioner to continue with the said contract. The rates at which the petitioner was continuing with the contract and was granted the extension was ranged between rupees 79 to rupees 85, depending upon the distance. First, the rate at which now the contract is being awarded is much lower. First, under such circumstances, it is the opinion of this court that this is not a fit case for exercise of jurisdiction, inasmuch as the petitioner was unwilling to supply even at the rate much higher than what is presently being granted to the respondent number 6, 7, and 8. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, this court is not inclined to interfere with the rejection. Number one, the rejection of the petitioner's technical bid in the by the impugned minutes dated 25/8/2025 was not in accordance with the terms and conditions of the contract of the notice inviting tender. Number 2. This court, however, would not like to interfere with the tender process. For the reasons already discussed above. Number 3. Petition accordingly stands dismissed with the above observations. What is this? Huh?
So the patta has been cancelled by the respondent number 2.
What? Copy of the patta, copy of the receipt.
Patta granted in favor of the petitioners has been cancelled. This is not a investigation.
Where is the order?
At page 20 annex 4.
Notice?
Notice has not been given, my lord.
No notice.
No notice, my lord. We are not aware about anything about that.
Whether the notice has been given or not, my lord, that instruction I have to take.
Which state is? This
It-
cannot
it
happen
was-
like this.
It was passed on, my lord.
First of all, it's a bench 5 matter.
Lordship. It was passed on, my lord, the
Isn't
September
it a bench
2024.
5 matter?
This is a bench 5 matter.
But anyways, it has come in the list
Lordship.
under the authority of the Chief Justice. The Chief Justice prepares the roster. I can exercise. Anyways.
Order
This
was
is-
passed on 2024, Lord.
So what? But this is not done. You have to, where is the state that it is notice is there? Secondly, you have to, not only that, where is the adjudication?
Lordship.
Merely because the Kacha house is not there, it's gone.
Lordship, my lord, only because of, my lord, that the one memorandum application has been received from the, my lord, that Assam Tea Tribes Student Union. My lord, they say that this land is, my lord, belong to, my lord, that Rajmai Tea State, Lordships. They are encroaching, my lord, that some portion of land. Now, that's why, my lord, it has been given. In the order sheet, it is reflected.
Did you inform anybody? Nothing?
Lord, that, my lord, instruction I did not yet receive.
Okay, which state? Issue notice. We have to give something. It's come in the last date.
Otherwise, I have to
Huh?
open instruction regarding that, my lord, whether any notice has been served. to
Not
the
necessary,
person.
but I think this is a stay because there again you may go to Mission Basundhara and give it to somebody else. Third party rights will be involved. He has come late. Why have you come late? And even the notice copy is also not furnished to him. See? Copy should be given to him.
Lord.
Issue notice making it returnable on
Hmm.
9th of February 2026. Mr. J. Hendrik appears on behalf of the respondent number 1 and 3. Mr. K. Gogoi appears on behalf of the respondent number 2 and 4. Extra copies of the writ petition being furnished during the course of the day. The petitioner herein was granted a settlement of a plot of land at measuring 2 kathas. How much? 2 kathas. Bearing dag number 1822 of Patta number 136 of village Rajmai Grand under lot number 4 under circle Dimo
Timor Revenue Circle, Thara Mode.
Thaura Moja in the district of Sibsagar, Assam. It is the case of the petitioner that without any notice the said settlement so granted to the petitioner was cancelled, which the petitioner only came to learn was cancelled by the respondent number
2, Lord.
2. Mr. Gogoi is correct. Respondent number 2. Which the petitioner came to learn only recently. What is that provision of regulation? Notice is required.
Regulation 90 says, my lord,
Again, see, 26, I suppose. 26, na? You see? Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that Regulation 26 of the Assam Land and Revenue Regulation 1886 categorically mandates that prior to cancellation of the patta, it is the mandate of law, it is the requirement of law to issue notice. Full stop. The learned counsel further submitted that even the order, impugned order, dated 17/9, na?
17.
yes, my lord, 17/9/20.
To 2024 has also not been marked to the petitioner. So taking into this court have also heard Mr. J. Hendick, the learned counsel appearing on behalf of the Revenue Department, and Mr. K. Gogoi, who appears on behalf of the District Administration, Sibsagar. This court, taking into account the above aspects, and also upon a perusal of the impugned order, is prima facie of the opinion that the same appears to be in conflict with Rule 26 of the Assam Land and Revenue Regulation 26 of the Assam Land and Revenue Regulation 1886. Accordingly, this court therefore stays the order dated 17/9/2024 passed by the District Commissioner, Sibsagar, whereby the settlement granted to the petitioner in respect to Dag number 1822, Patta number 136 of Rajmai Ground under Thaura Moja Dimo Revenue Circle was cancelled. Take steps today itself.
What's it, fix it one? Fix it or returnable?
I fixed it, date 9/2.
Oblation.
Now what do you want? Last time you have withdrawn it. Not to claim any forest royalty from the petitioner in respect to the work executed by the petitioner in under contract, direction shall not be issued to the railway authorities not to demand so and so from the demand, direction shall not be issued. Okay. Now, forest royalty is being done under Rule 5.
Okay, petitioner has not obtained a mining lease. Petitioner has not obtained a mining lease. Petitioner has not been granted the mining lease by the authority, not obtained it from the forest department. So, as per rules, the forest royalty can be claimed when the lease is granted. As per 5, Assam minor mineral concession rules. Rule 5.
Yes.
An application for grant of mining permit for a query or any minor mineral by the Department of the State or Central Government or any other agency or any work or projects have been made by an officer authorized by the concerned department to the competent authority. The contractor engaged for the works, projects of the government department agencies shall be granted mining permit for the required quantity specified detailed project report for execution of the works, projects on making an application under sub-rule 1. Department or agency or the contractor granted permit under sub-rule 1 above shall be liable to pay royalty. I have no mining list. I have not obtained, I have purchased from the local vendors.
Mister, this is a wrong book. This has been amended long time.
And who also be
No, you, where is that? Mr. Goswami,
Fine.
again, this time is a case for dismissal.
9 also lots.
Paragraph 7 onwards.
I have given some judgment here, na?
Lordship has given NC Das that was put to silence in this case.
Para
Lordship.
7 where?
Para 7 onwards, Lordship. Single bench, my lords have passed the order. Today I not bring the single bench order, Lordship. That was put to silence before a division. No, Lordship. Even Lordship, the findings of the honorable court is paragraph 12, Lordship.
Where?
Paragraph 12, Lordship.
No, where is my judgment?
Lordship judgment today I forgot, Lordship.
No, that is
I-
some judgment, Muslim Ali or something.
No,
No,
even-
there is another judgment, no.
Even else,
And more particularly, this is a judgment, another judgment is the judgment on by which I set aside that
Private construction also.
private construction. That private construction judgment is going to help you out.
even Lordship, what in NC does, my lords have in the single bench, my lords have passed the order, Lordship. Today I not.
The only issue is that he doesn't have to have a mining lease. The petitioner, he doesn't have to have valid.
No, it's not required. No, he is referring to a wrong provision.
Even
That
Lordship,
provision is already amended.
Asking for, give us a clearance certificate from where you have
Lord.
got the raw material. That's it.
even
He
Lordship,
has to get the forest clearance certificate and then they won't ask you.
even Muslim Ali was discussed in this division bench judgment, Lordship. Muslim
Oh,
Ali.
this one, yeah. Whether, this is mine.
is single bench.
No, not this one. No.
NC does was single bench.
Whether state authority public or the other can deduct for the forest reserve from the field security level in excess of the- This is another aspect. This is without a stipulation. There is another aspect here. I have delivered that judgment. Where is that?
Even Lordship in the NC does, Lordship has single bench judgment.
No, give me that book. এইখন আমি এখন দিগন্ত দাসৰ পৰা লৈছিলো যে মাইন্স এণ্ড মিনাৰেলছ এইখন কিনি written by Mr. Kostov Gogoi.
Rule 9 also.
Not rule 9, rule 5. Let's see 5 where it is. See? 3. Minor minerals when shall be used or consumed by the government department. The rates of royalties shall be paid as per the rates specified in the third schedule. You have not a 3.1 appended to these rules here. The minor minerals when used or consumed by the central government or any agency, the rates of royalties shall be paid so and so. Now you see any application for grant of so and so or many minor notified so and so or any other work shall be made by an officer authorized by the year. Engaged in the works, projects of the government's ventures shall be granted mining permit for the required quantity as specified in so and so as above. The minor minerals when shall be used or consumed by the government department. The rates of royalties shall be paid as per the rates prescribed in the third schedule appended to these rules, and other ancillary charges as may be notified shall be deducted by the government department through the treasury in proportionate rate. Yeah. The rates are here. You need to look into that. You get an answer in that judgment which I said that this forest department or anybody cannot ask from private construction. Have you got that judgment?
Yes.
Where is that?
After some time, I produced it.
That is the judgment where I deal.
Lordship.
But you have one aspect. I dealt with another very important aspect which you should have noted and you have filed your writ petition on that basis. You see, these rules are being made in terms with the Mines and Mine and Mineral Development Act. That there is a particular mention how you can charge, but that judgment is not there.
Rule 9 also specifically stated.
No, Rule 9 is won't help you. Rule 9 is different. A register of application for grant of renewal. This is different. But you see, what they have done by this amendment, those rules first, normally what happens, if you are doing a railway contract, the railways ask the PWD or this forest department kindly provide us a lease, and that lease is being granted to you. So this is how it is. This is one. And two, how it is to be given. But sometimes what happens, lease cannot be granted. In many cases, not only railways, many other cases may not be able to get that. So then what you have to do is, they will deduct that from the royalty. This is the provision how it is to be done. Now, this is not being taken note of. You look into that judgment. We have it after vacation.
Lordship.
But look it into that judgment. There I have dealt with, and there is a very important aspect which I have mentioned in that judgment, that this Rule 5, which is being amended, does not appear to be in consonance with the Mines and Minerals here. And I have given the due reason. I almost not looked into that for a long time. This judgment which he is referring to is another case. He is referring to that, you see, if a foreign clearance certificate is being given, then it is okay for you. But the fact remains, oh, now I remember. There cannot be a royalty charged twice. Royalty cannot be charged twice. If you are purchasing from A, who had already paid the royalty at the time, because as per the Mines and Minerals Act or the rules, the royalty is to be paid by the person who is extracting. So once that royalty is already paid, there cannot be again. And if you have already purchased from somebody who has already paid the royalty, then you cannot be charged. This is an aspect which is there in that judgment. Have a look at it. He knows it. He was there. So you have to look into that, not this. No, he's not applicable. It's a different thing, but he has to come up with that. So you have to give that certificate to be excluded. Is you have purchased from somebody who have already paid the royalty, because there cannot be twice the royalty.
Even in that particular case, my lord said, regarding the source part, my lord says clearly discussed in the single bench judgment, and see the single bench judgment, my lord has discussed that.
No, there's no quarrel about that. But my question here is, he can escape. That there cannot be I can very well pass a direction to the state, the railways, that kindly don't deduct. But in that case, you have to provide that from the person from whom you have purchased,
Source lord.
he has already paid the royalty.
That part.
In fact, day before yesterday, Lordship had directed me on NRL matter, my lord.
Yes, And you said that you have
Yes,
nothing
we'll
to.
verify, my lord. We said we'll verify here, any
Ah.
some documents that show.
So that is why he filed, in that matter, he had filed that application. An additional affidavit that he has purchased from all these people who have already paid. So then you don't need to.
Then here in
Just
this,
for example, you are getting stones from somebody, you have to get that. Find out that aspect and more particularly read that judgment. You'll get an idea.
only
And
source
there is
part
no
we can
appeal
produce,
against
then
that.
no issue.
Mr. Gogoi, no appeal against that GMC thing?
No.
No. So that has attained finality. So you look into that.
GMC attained finality on the basis of that my lord judgment, Sebail under single bench judgment also come. Lordship.
Oh, it's finished.
It is finished, lordship. Otherwise, if he produce the source, lordship,
And every
then
time it was granted a stay going on. So one fine day I thought that okay, without the council arguing. Anyway, Mr. S.K. Goswami, the learned counsel submits that he would seek for an accommodation and let the matter be listed immediately after vacation. List the matter on 7/1/2026. You look into that judgment, you get a fair idea. But Mr. Goswami, it was not proper on the part of you or your assisting counsel to place before me Rule 5 as it was prior to the amendment. It is expected for a council of your stature to be, and this amendment happened long time. Oh. Any update?
Perhaps, my lord, it was listed day before yesterday.
Hmm.
My lords had expressed my lord's mind that my lord will issue notice. Let a notice go.
No, I will issue notice of contempt now.
Lords. Because few things we are also not able to handle.
Huh?
Because earlier there was a report.
Because the report was given to me.
Now, no,
And
there's
I've
no
kept
dispute
it
with
wherein
that.
it is categorically said that the amount is so and so. And as such, however, it has not been paid.
There's no quarrel about the amount. But certain other issues, administrative issues have cropped up. That's the reason it has been again sent back.
No, whatever may be, you see, the problem which appears is there's a direction to pay within a particular period.
My lords.
And if you don't comply with that,
My lords.
it doesn't look nice. There was a direction not later than 3 months. And I guarantee you, this order was passed when? 3/3/2025. I've been extending the period. Today we are in the month of December.
Well, let's
Yeah.
let notice go. Well, you see.
Lekhok.
Completion.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The instant application has been filed alleging willful and deliberate violation to the order passed by this court on 3/3/2025 in WPC number 3857/2024. A perusal of the said order passed by this court reveals that this court categorically directed the respondent authorities to verify the claim of the petitioners and if found admitted, to release the admitted amount claimed by the petitioner. It was further directed that a verification to be carried out be made within a period of 1 month from the date of receipt of the certified copy of the order, and if found admitted, the same shall be released to the petitioner within a reasonable time, but not later than 3 months thereafter. Full stop. The said order dated 3/3/2025 was served upon the respondent. Herein, the respondent number 1 herein on 10/3/2025. Full stop. It is also seen that the certified copy of the order was also served upon the other 3 respondents to the instant proceedings. And this aspect is also to the knowledge of all the four respondents herein, as would be apparent from Annexure 3 to the contempt application. Be that as it may, this court, taking into account that the instant contempt application was filed Annexure 3 no. Also apparent, yeah. Where is the other, what is this document? 27.3? This is the different document, na?
27.
এইটো এয়া লেখক এইটো সেই লাষ্ট লাইনটো গুচাই দিব বাকি কিটা ৰেছপন্স was received on 10/3/2025 huh be that as it may there is no document on record to show that a service of notice have been effected upon the respondent numbers 2, 3 and 4. Next of the present proceedings. Next, be that as it may, on 26/9/2025, on 10/9/2025, when the matter was listed before this court for motion, this court requested Mr. Aibor Thakur, the learned standing counsel of the PHE department, to obtain instructions as to whether the order dated 3/3/2025 passed in WPC number 3857/2025 is complied with or not. Full stop. X con code goal. Huh? Hey, হুনো X document full stop. এখন on ঠিক আছে এখনো নেলেখি কেউ on 26/9/2025, comma, it was informed to this court that due verification was carried out and it was found that the petitioner was entitled to an amount of rupees 13,85,500. And all the claims which were made were duly admitted. This court accordingly directed. This court accordingly asked the standing counsel of the PHE department. Now, it was further informed to this court that the said amount would be cleared within a period of 3 months from today, from the date. Be it as it may, the petitioner have not made any payment. When the matter was listed before this court on 17/12/2025, Mr. Aibor Thakur, the learned standing counsel of the PHE department, submitted that though the amount is admitted, but there is further requirement that there are further administrative approvals required. They said, apparently, this court therefore fixed the matter today for motion. Next. This court appreciates the assistance provided by Mr. Aibor Thakur, the learned standing counsel of the PHE department, and dispenses with his appearance Next. From the above, it is apparent that even after verification being carried out, the amount which is payable to the petitioner have not been paid. The said payment was to be made by June 2025. And today, and as the matter is being taken up today, 9 months have passed by. Considering the above, it therefore, this court prima facie is of the opinion that the respondent number 1 have undermined the majesty of this court as well as the directions passed by this court, and these directions passed by this court have not been complied with. Consequently, this court therefore issues notice upon the respondent number 1 why contempt proceedings should not be drawn against him. Reply be submitted by the respondent number 1 on or before, list the matter again on 9th of February 2026. Petitioner is directed to take steps upon the respondent number 1 by speed post. In addition to that, the petitioner is directed to effect service upon the respondent number 1 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First, list the matter on 11/2/2026. The respondent number 1 shall file its affidavit in opposition as to why contempt proceedings should not be drawn against him on or before 4/2/2026.
Great, Vijay Vasu. So this is regarding that area TF case also, Lagasa plantation. So on the last occasion, Lawson was asking me whether any payment has been made or not. That document is already there at page 65. We have made an amount of around 4.96 crores for PF for the previous years. But because of this particular period of lean periods now, this is the difficulty we are facing. That is why this IA we have filed, taking a 1 month time. So Lawson, what we are looking forward is for a solution. The fact remains that today we are not in a position to make this payment because there is no revenue being generated, and rather we are making payments to run the entire tea estate, and the labor payments and everything has to be made. So that's what I am asking is, initially what our case was, the arrangement that was given to us was till October 2027. Payments were to be made till October 2027, 36 months. Suddenly it was taken out from us, and now what they have given is only 10 months. Ultimately, they are creating the problem has been made more. Instead of trying for a solution, the problem has become more difficult for us now to solve, Your Lordship. And the other thing is, the checks that we had given to them at that point of time, though we had given them at a late period, but within that 36 months itself, we wanted to clear the entire amount. Those checks are still with them. It's not that they have returned those checks back to us also. We are committed to make the payment, but the problem is we are looking for a solution to make the payment. At the time given to us is 10 months. Practically, I'm telling you, Lordship, it's not possible for us because there is no revenue with us because once the press tea leaves comes, only then the revenue generation takes place. And from
Mr.
then we
Sharma,
make the
this
payment.
amount of PF is a statutory due.
I understand, Lordship. There is no quarrel on that aspect, Lordship.
If you are not depositing, you have minimum 50%, whatever may be, 50% belongs to you. And 50% you have already taken from them.
Yes.
And it is a case of misappropriation. It's a case of misappropriation.
Yes, if we
No, there is no quarrel. That is the proposition of law. I am not saying for myself that it's a misappropriation. It is a case of misappropriation as from the provision of law itself, that you are therefore liable to pay from yourself 50% and 50% from them. That 50% from them, you have put it to yourself. And whatever I asked you to rate, the total dues is some 2 crores something.
2 crore
I've asked you only to pay
63.
63, which is 1/4. Means it is less than, not only less, it is just 25%.
And also, what we are saying is, we are only
You
asking
had
for-
the money, you used it somewhere else. You have, while making payment to them, you have taken away from them that money. You have not given it to them. This money was to be deposited along with your share. That's the law. So the question is, later on, now you realize that it has become it's a very difficult
So
proposition,
what I am,
insurmountable for you.
what I am praying is, the arrangement that was given to us by the PF department
That
themselves,
they have,
that is
you see, the
restored back.
reason why I'm saying is that the reason is very specific. The arrangement was given by them. By 15 days, we are to deposit these checks. You did not do that.
But
When you
we-
don't do it, then their installment facility which they have given will fail.
but
I'll
we
help it
gave
with
the
that.
checks- We gave the checks to meet the liability.
You
within
gave the
36
check
months itself.
subsequently. You gave the check subsequently, of which 3 or 4 checks now have become
No, they-
redundant. Yes,
No,
3 months.
The checks were from the month of April,
So,
and they rejected. the
so
arrangement.
therefore, from the month of April, from month of June, those checks can't be used for 3, 4 months. Do you see that?
Because of the,
3 months.
A check is valid for only 3 months.
3 months.
Then
the other checks will be there, but. then-
other checks,
but-
whatever, which means they can now only put only one check.
No,
Which is
but
of that
what they
period.
did was, they pulled back from the arrangement in the month of March itself. The checks were to be put before the bank on the month of April. They had passed the impugn order on the month of March.
So that is why you have thereafter you have given that.
Because if the checks were given, if I may just place the date losses.
Lordship, there's one more aspect in that order of 2024. There were
checks were-
certain heads which were supposed to be paid immediately, and only the PF areas were supposed to be paid in 36 installment. And those immediately, that's why the EMI or the monthly installment was 6 lakh something odd amount. They have that immediate amount also, they have included in the monthly installment and given checks of 9. So they have not accepted our proposal.
No, they
And
are
in
to-
the impugn order also, Lordship, those 4 heads were supposed to be paid immediately. The PF area were supposed to be paid. And your Lordship's orders also, out of those 4 heads, 2 heads were supposed to be paid now, and rest will be considered. So those heads that were supposed to be paid immediately were never paid or honored. Even they have not accepted in the checks also. The checks were monthly installment of the entire amount, entire due, which was never the proposal from the PF.
The PF department proposal was for 6 lakhs. The checks that we gave was for 9 lakhs. Because we made the payments, they were supposed to make from October. We gave it from April. So therefore, to meet that timeline of 36 months, what we did was we increased the amount, we enhanced the amount. What they asked for 6, we gave 9. And the checks were given on 10th of January 2025.
You see, when that was given, within that 15 days, did you correspond with them that look here, on such and such date, we are not positioned, we will be paying you from 9 months, from the
I do
month
not
of
have
April.
correspondence on record, but then what my instruction says, it was done only after communication and discussion with them in the office. And that is how this order, this checks were made on 10th of January. And the impugn order came in the month of March. While the checks were supposed to be encashed from the month of April, Lordship. And the checks were taken by them. If a Lordship will kindly see, just for a moment, Lordship, the order, page 59 orders for a moment, Lordship, by which the arrangement was given to us for 6 months, for 36 months. That was, Lordship, page 59. This was the order of 29 October 2024, wherein they say that 36 months installment, you clear this amount at the rate of 6 lakhs. What we did was, and they asked us to make the payments immediately within 15 days. We could not do that. My instruction is that we approached the office And thereafter, what we did was on 10th of January, we made the entire amount by way of 24 checks. There has to be 36 checks. What we did was we gave 24 checks to meet that 36 months outer limit itself. And the amount was enhanced to 9 lakhs so that we do not cross the outer limit of 36 months. We gave them checks on 10th of January. The checks were supposed to start from
Mr. Sharma, you were supposed to deposit from October onwards till date. Almost
36 months would have been October 2027 law.
till date, I'm saying. From October, if we take at 6 lakhs also,
Yes, yes.
till date, you were supposed to deposit something around 12 to 72, 84 lakhs.
Yes, roughly.
84 and 96 lakhs. 14 into 6, how much? 84 lakhs. 84 lakhs.
84.
I've asked you to deposit only 63.
We are agreeable to make the deposit.
We have
Only-
not done that.
Only thing that we are asking for a month period of time.
Why? Why should we give you?
That is the only prayer we have, Lordship. By filing this IA, because Lordship has given us a date of 15th.
No, I can only
15th of
give
December.
you time till January 1st, 96 lakhs. Because the fact remains, as per your own, let us take your submission. You had read, you instead of 6 lakhs, you gave 9 lakhs.
Yes, Lordship.
Okay. So you say that for these 5 months, 6 months, we are not going to pay anything. But we are going to pay from 9 lakhs onwards from then. And we are going to complete within 24 months.
24 months, yes.
That's your stand.
That was our. And we gave checks accordingly, they accepted the checks.
It's okay. But if it, let us take the case of a 6 lakhs, which they have said, 6 to December will be 14 months for the month of October onwards.
Yes.
14 months plus usual dues comes to easily to 94 lakhs. Then you are not in a position to pay that. So you do one thing, let this matter come up after vacation. I won't be taking a bench for. You may have a lucky judge.
I will not comment anything.
No, you may
The
get.
only thing is that we are
But
looking for a solution.
I am not going to touch this order. My order seems to be perfect. In fact, I wrong to pass that order. I think so. That day I was very good.
We
60.
were very thankful as to what your lordships have passed this order, but the difficulty is that the actual position is they don't have money to pay.
And you
And
can't,
therefore they are
and
asking
if
for
that be so, the question of extension doesn't arise. The lean period is till the month of February
till
or
February.
March.
Yes.
Now, as per the T-board circular, this is a tea industry.
Tea.
The T-board circular, you have to stop plucking from the month of, I think, 15th of November onwards. You start pruning and all, and it will end sometime in the month. And it's the first year will start from 15th of March. So till 15th of March, you have no money, so you can't pay a single penny. Then where is the source of revenue? You have to show us that, okay, 1 month if I have give you, how are you going to pay that?
My instruction is 1 month time. we
No,
pay
no,
that.
how? How are you going to
That
pay?
I have not asked
Then
them because of that.
Don't
Business
ask for
operations, I have not asked them
extension
how
like
they are going
this.
to do it.
No, no.
But what they have told me, 1 month
Leho.
lean period, if they can get over this, they will be able to make
No,
business. And that I am communicating with your lordship.
we reject, well, let us reject this application. Now, heard Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. R. Sharma appears on behalf of the Provident Fund authorities. First up, this is an application filed seeking an additional 30 days to comply with the order dated 24/11/2025 passed by this court in WPC number 6613/2025 by depositing the amount of rupees 63,935.52. This court inquired with Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner, as to why the petitioner could not deposit the said amount in terms with the order dated 24/11/2025. It was submitted that the petitioner, that this is the lean period in the tea industry. And as such, there is no funds coming. Full stop. It is. Full stop. This court can very well take judicial notice of the fact that in view of the tea board circular, the lean period for the tea industry in Assam starts from the month of late part of November till the second week of March 2025, to the March. Full stop. There is no materials thereupon has been placed as to how the petitioner under such circumstances would be in a position to deposit the said amount within a period of 30 days. So, taking into account the above, this court does not find a good ground for extending the benefit of the interim order dated 24/11/2025 to the petitioner. Full stop. Accordingly, the instant application stands rejected. Full stop. Ekon Devo, you have filed your affidavit?
No.
So Mr. R. Sharma submits that he would like to file an affidavit in the instant writ petition. List this matter when?
In the third week of January. Or
Is the matter again on 21/1/2026. The writ petition.
oblige, Your Lord.
So what have you thought?
I'm agreeable to your lordship's proposition of sending the matter back and a reconsideration from the technical evaluation stage, lordship.
My part, lordship will interfere, my lords, but lordship, just observe that I have on the strength of that contract, but I have done some work.
Why will I observe that?
That's my lords.
That is your lookout. See, tomorrow, if you don't get it, Mr. Gogoi, you are always open to make claims. I will observe that is your submission, and I will say that is absolutely within the liberty, the respondent has liberty to take action if it is not granted the contract later.
Well, that's
That
right.
only I can say. I cannot say that anything because it will be very difficult for me to go there and look into it.
I have annexed certain photographs in the official affidavit that we have filed from the corporation, wherein we have admitted to the fact that substantial work has been done and accordingly photographs have been annexed.
So that becomes your proof.
Yes, so that admission on our part is always available.
No,
on
why?
record.
So that becomes, that
That's-
is
it
already
is-
on record.
It is on record, lordship. It is on
That
record.
will suffice.
So I will consider that as your submission. He should have asked the petitioner to withdraw. He also knows he is not going to get any subsequently relief, but here he is getting it. He won't get a subsequent relief. He also knows on a reconsideration, but that fact remains otherwise. Petitioner would have been also happy.
Number 4 is also the same thing of the petitioner. He also not submitted, madam.
Huh?
But a clause, .6, Roman 6.
He has not submitted what?
Income tax return that was saying, but the technical evaluation does not say so. Technical evaluation says he has complied with every requirements of the tender.
No, you will again reconsider.
Yes, everyone will have to reconsider.
All the bidders you will reconsider.
Yes,
Then
everything.
if you can very well take that plea later on, if he has not.
Yes.
And this was submitted by e-portal.
Important.
So it will be now open. That is the only document. No further documents
Yes,
will be allowed to either of the parties. Both the writ petitions are taken up together for disposal. Heard Mr. Ellen Dihinya, the learned counsel appearing on behalf of the petitioner. Mr. A. Sharma, the learned counsel, standing counsel, appears on behalf of the Assam Plain Tribes Development
Development
Corporation Limited, for short, the corporation. And Mr. D. Gogoi appears on behalf of the respondent number 4 in both the writ petitions. Both, na?
Both.
And Mr. K. Gogoi appears on behalf of the respondent number 6 in both the writ petitions.
No, my lord.
Not in both.
My lord, one, my lord. Number 14, my lord. 707.
In respondent number 6 in WPC number 7076/2025. The petitioner herein has filed two writ petitions. Have filed both the writ petitions. WPC number 6542/2025 is the writ petition filed by the petitioner being aggrieved at the rejection of its technical bid. Whereas WPC number 7076/2025 is the writ petition filed by the petitioner challenging the work order dated 14/10/2025. Before proceeding, this court finds it very pertinent to observe that the tender in question was floated by the corporation on an online mode. Online, na? However, it is an admitted fact that till the filing of both the writ petitions, the work order dated 14/10/2025, which was issued in favor of the respondent number 4, was not uploaded in the e-portal. In the backdrop of the above, let this court now deal with the facts, material facts, which are relevant for the adjudication of the present proceedings. The corporation, through its managing director, issued a notice inviting tender, inviting bids from registered eligible contractors firms registered under the corporation for upgradation and renovation of a building of hostel number 3 of Nagaon Polytechnic, Nagaon, under SOPD-ODS during the year 2023-24. Note 2 of the detailed notice inviting retender, bracket for short, referred to as the NIT, stipulates, note 1 of the notice inviting of the NIT stipulates that the contractors of the bidders must be registered with the e-tendering system provided for participating in the bidding process. Note 2 stipulates online submission of the technical and financial bid is mandatory, and manual submission without online submission of the bid could be considered as non-responsive. The last date for submission of the bid was on 28/7/2025, and the date of opening of the technical bid was on 28/7/2025. The petitioner, along with various other bidders, participated in the said notice pursuant to the said NIT dated what is the date?
Page 28. 23.
23-5,
25.
23-5, 2025. Amongst the four bidders whose technical bids were considered, bids of two of the bidders, including the petitioner, was rejected. Whereas the bids of the respondent number 4 and another Seed Construction Co. were allowed, were technical bids of so and so were found to be substance compliant. The reason for rejection of both the bids of the bids of two of the bidders were noted in the comparative statement bracket technical bid. In the case of the petitioner, the reason was, inverted comma, IT return and turnover not submitted for the last financial year 2024-25, inverted comma, close. And in the case of one Lakshajit Setia, Lakhyajajet Chetia, it was rejected for the reason, inverted comma, IT return not submitted for the last financial year 2024-25. The petitioner, being aggrieved by the rejection of the technical bid on the grounds stated in the comparative statement, had approached this court. It is the case of the petitioner that for the purpose of filing the returns for the assessment year for financial year 2024-25, the last date for submission was on 31/10/2025 as per the circular issued by the Deputy Secretary to the Government of India, Central Board of Direct Taxes, dated 25/9/2025. It is the further case of the petitioner that this was further extended to 10th of December 2025, as would be seen from the circular issued on 29/10/2025. The case of the petitioner, therefore, is that on the ground of non-submission of the IT return and turnover for the last financial year 2024-25, the petitioner's bid could not have been rejected. More particularly, when the last date for submission of bid was 28/7/2025, until then, the financial bid, as per the financial, till then, the IT return for the financial year 2024 and 25 could have been submitted up till the period for submission of the IT return for the financial year 2024-25 was not over. When the writ petition was listed before this court on 19/11/2025, it was submitted by Mr. A. Sharma, the learned standing counsel for the corporation, that In the meantime, the work order has already been issued in favor of the respondent number 4 on 14/10/2025.
Being summoned in 423.
Please. And the respondent number 4 has already submitted the performance security. Under such circumstances, without the challenge to the work order dated 14/10/2025, this court was of the opinion that it would not be in the interest of the justice to pass any interim directions. However, this court made it very clear that the award of the work to the respondent number 4 shall be subject to the outcome of the present writ proceedings. And the respondent number 1 shall not be permitted to claim any equity on the basis that this court did not pass any interim directions on that day. The record reveals that the respondent corporation had filed a preliminary affidavit on 10th of December 2025. To the said affidavit in opposition so filed by the respondent corporation, the notice to proceed with the work dated 14/10/2025 was enclosed. And certain photographs have also been enclosed that the respondent number 4 have already started the work. It is very pertinent herein now to take note of that the respondent corporation in the affidavit have categorically stated that the reason for rejection of the petitioner's bid, technical bid, was on account of clause 4.3 Roman 6 and clause 4.3 Roman 13, inasmuch as the petitioner have not complied with the same. First, at this stage, this court finds it pertinent to take note of clause 4.3 Roman 6 and clause 4.3 Roman 13, which being relevant are quoted herein under. Page 36 or 37 of Pawaha, Econ 6542. A perusal of the above two quoted clause reveal that the bidders are required to submit the audited reports on the financial standing of the bidders, such as profit and loss statements and auditor's report for the past 5 years. And further, the bidders were also required to enclose the income tax returns of the last 5 years. There was no mention, however, as to what these last 5 years would mean in the notice inviting tender. Next, the petitioner, in the meantime, being aggrieved by the issuance of the work order dated 14/10/2025, filed the second writ petition being WPC number 7076/2025, wherein the work order dated 14/10/2025 was challenged. This court issued notice on 12/12/2025. At that stage, on the same date, it was submitted by Mr. A. Sharma, the learned standing counsel of the corporation, that the affidavit so filed in WPC number 6542/2025 would suffice for the purpose of the present writ petition of WPC number of the writ petition registered as WPC number 7076/2025. Full stop. This court, this court further finds it relevant to take note of another pertinent aspect. When both the writ petitions were taken up on 12/12/2025, this court, taking into account the contents of the reasons so cited in the comparative statement and the recent judgment of the Supreme Court in the case of the state of Himachal Pradesh and others versus Oasis Cybernetics Private Limited, reported in 2025 SCC Online SC 2536, inquired with the learned standing counsel appearing on behalf of the corporation as to whether there are contemporaneous materials such as minutes of the meeting recorded by the tender evaluating committee, mentioning about the reasons pertaining to clause 4.3 Roman 6 and clause 4.3 Roman 13. Accordingly, this court fixed the matter on 17/12/2025 for further consideration. Next. On 17/12/2025, when the writ petition was taken up, Mr. A. Sharma, the learned standing counsel of the corporation, have placed before this court a communication issued by the managing director of the corporation. They said the contents of the said communication, being relevant, is reproduced hereunder. Further to that, as the said communication is pertinent, the same is kept on record and marked with the letter X. From a perusal of the said communication, it is seen that the respondent of corporation have not maintained any contemporaneous records or minutes of the meeting, which would show that there was a consideration to clause 4.3 Roman 6 and clause 4.3 Roman 13 while rejecting the writ petition, the technical bid of the petitioner as well as the other bidder. In the backdrop of the above facts, this court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. The instant writ petition has been filed challenging the rejection of the petitioner's technical bid. In the foregoing paragraphs of the instant judgment, this court have reproduced the reason why the petitioner's bid was rejected. The said reason so mentioned has no semblance of any connection with clause 4.3 Roman 6 or clause 4.3 Roman 13, inasmuch as the said reason was specific to clause to non-submission of the income tax return as well as the turnover for the financial year 2024 and 25. In addition to that, non-submission of the return for the financial year 2024-25 was not a requisite as specifically mentioned in the tender terms and conditions. The reason being specific to the reason being that the last date for submission was on 28/7/2025, whereby for the financial year 2024-25, the last date for filing submission is on 10th of December 2025. Therefore, at this stage, this court finds it relevant to take note of the recent judgment of the Supreme Court in the case of Oasis Cybernetics Private Limited, Supra, wherein you got it? Wait. And more particularly, paragraph number 26 to 28 of the said judgment being relevant is reproduced hereunder. From a perusal of the above quoted in addition to that, from the above quoted judgment paragraphs, from the law settled by the Supreme Court in the above quoted paragraph makes it clear that the reasons need not be stated in HAECVERBA in the communication, so long they can be discerned from the file and are not post hoc justifications. The Supreme Court made it very clear that the practice of post facto rationalization, whereby the authorities attempt to supplement or fabricate reasons after the decision has been taken, cannot be accepted, inasmuch as such afterthoughts cannot cure an inherently arbitrary action. In the instant case, as noted above, the reason which was cited for rejection of the petitioner's technical bid in the comparative statement cannot be a reason as permitted under the tender terms and conditions. In view of the fact that there was no necessity of filing the income tax returns till 10th of December 2025. And there was further no mention in the tender terms and conditions that the requirement of filing the financial return up to the income tax return up to the financial year 2024-25. However, the reasons which have been submitted by the Learned Counsel appearing on behalf of the respondent corporation. Based on the affidavit so filed by the respondent corporation, appears to be a classic case of post-factor rationalization, thereby trying to supplement or fabricate reasons after the decision has already been taken. In this regard, this court finds it relevant, profitable to refer to the judgment of the Constitution Bench of the Supreme Court, judgment of the Constitution Bench of the Supreme Court in the case of Mohinder Singh Gill versus Election Commission of India, reported in 1978, 1 SCC page 1, and more particularly to paragraph number 8, which is reproduced hereunder. First, under such circumstances, it is therefore the opinion of this court that the rejection of the petitioner's technical bid was a case of malice in law and malice in law, arbitrary, irrational, and unreasonable. First, at this court now finds also pertinent to take note of the submission of Mr. D. Gogoi, the learned counsel who represents the respondent number 7-4, and submits that the respondents have also, respondent corporation have duly admitted that the petition, respondent number 4, had carried out various works. This court would not like to comment on the said, taking into account that while passing the order on 19/11/2025, it was made clear that not granting any interim direction would not create any equitable interest in favor of the respondent number 4, and the work order would be subject to the outcome of the writ petition. At this stage, this court also finds it very pertinent, apposite to observe that it is also an admitted case of the respondent or corporation that till the filing of the date on which both the writ petitions have been filed, the work order dated 14/10/2025 was not uploaded in the e-portal, which was a necessity to do so as per the Assam Public Procurement Act 2017 and the rules framed therein under. Consequently, this court therefore disposes of the instant both the writ petitions with the following observations and directions. Number 1, the rejection of the petitioner's technical bid by the respondent corporation in the minutes by the comparative statement dated 8/10/2025 is bad in law and accordingly set aside and quashed. Number 2, as the very technical bid, as the evaluation of the technical bid is being set aside, the consequential work order so issued in favor of the respondent number 4 cannot be cannot also stand the scrutiny of law, for which the same is also set aside and quashed. Number 3, the respondent corporation is directed to afresh evaluate the technical bids of all the bidders who submitted the bids and thereupon proceed the evaluation of the tender in accordance with the terms and conditions of the notice inviting tender, NIT. Number 4, the setting aside of the work order dated 14/10/2025, however, shall not preclude the respondent number 4 to make claims against the respondent corporation if so advised as per the provisions of law. Last day also I am disposing. এটা line এটা লিখি দিয়া। It is categorically made clear that while evaluating the technical bid, the respondent or corporation shall not permit any of the bidders to resubmit any further documents.
Oblige, Your Lordship.
Then you may have again come here,
Respondent number 5 is the same putting minor.
4/4.
I also.
Okay. So therefore, we are, I'll see you again next year, but not me, anybody else.
Oblige, Your Lordship.
Well, last, I have already served the copy to the standing as an Assam State Corporation.
You have given?
Yes, sir.
Chalo. এখন notice issue করে দিব। Returnable on 23 March and affidavits to be filed by 16 March. Lordship, you are paying for Assam seats
Assam State Corporation.
and so. Give your names.
One and my lord, 1 and 3 by the my lord, agriculture, standing council agriculture department.
136.
136.
Which one?
This one.
Item number?
18.
18 is over. I passed the order. Huh. What type of writ petition is this? Huh?
I don't know. I have to put the petition. Or say if the petition has established a newly installed register. Strictly according with.
Let me tell you a case. You don't need to. That day you were not there, so I had the occasion of reading the file. The case is you were running some stone quarry. In view of some Supreme Court judgment that has been stopped. Now you want that this court should pass an order asking them to again renew you that stone quarry and further also direct the SBI not to take action against you.
And one new pressure ongoing.
What?
Within 3/002.
Set aside and quash the illegal and arbitrary cancellation order issued by DFO. This is done at the instance of the Supreme Court, isn't it?
My lord, but in the petitioner case, my lord, he is my lord stone crusher, not in the Karbi Anglong, in the my lord Kothiatoni Nagaon stone crusher unit. And he prays for my lord set aside the order issued by the divisional forest officer in some other cases. And he has not annexed any document here about the order of cancellation. In all those cases, Lordship has already heard all those matters, my lord, regarding Supreme Court's order.
Did you hear what he said? So you withdraw and refile properly. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that he wants to withdraw the instant writ petition in view of certain formal defects. Mr. J. Sutia, the learned standing counsel, appears on behalf of the Karbi Anglong Autonomous Council. You are appearing? Anybody? All are appearing. So accordingly, the writ petition stands closed on withdrawal. Liberty, however, is given to the petitioner to refile by removing those formal defects. But you should learn how to draft a petition, not in this manner. I thought Mr. Chaudhary has taken a vacation, early vacation. He was not there yesterday. So, but then again, I saw you. Huh?
If your lordship could kindly come to your lordship's order, Miller. Please come to page 106. Para 45. Accordingly, this court therefore disposes of the instant batch of writ petition with the following observations and directions.
Order dated issued by the District Commissioner Gwalpara set aside and quashed. Order dated 39/24 passed by the Principal Secretary to the Government of Assam.
Oh, is that cattle market?
Cattle market. Now, please come to 5 and 6, Milord. These are the 2 points. That this court having set aside order dated 39/24 passed by the Principal Secretary Government of Assam, directs the Principal Secretary Government of Assam Panchayat and Rural Development to again consider as to whether applications so submitted by the petitioner on 22/8/24 under section 107 seeking approval to run the private market can be granted approval or not. So this was 1 and 2, Milord. The 6. The petitioners in WPC have already been granted no objection certificate by District Commissioner on so and so in terms of the Act of 2001 and the rules framed thereunder for setting up the animal market and so and so. Under such circumstances, petitioners in WPC shall be bound by the said.
That is you.
So, my lord,
237 is yours.
yes.
Yeah.
Now, my lord, now your lordships directed to basic observation, my lord, that I'll have to seek permission from the Panchayat and the government. Now, my lord, none of the authorities have acted. Now, 2 orders have been passed, kindly see, my lord, at page 119 and 120. One by the Anchalik Panchayat and other by the Deputy Commissioner. So your lordship's order has not been implemented as yet. Kindly see, my lord, this is by Anchalik Panchayat at page 199. This is to inform you that as per section 107 of the Assam Panchayat Amendment Act, prior approval from the Panchayat concerned and the government is mandatory for operation of any private hut under the jurisdiction of the Panchayat area. It has come to the notice of the undersigned that Gornagar so and so does not have necessary permission from the
No, but did you apply?
Yeah, yes, I have applied. Well, now the Gram Panchayat will give NOC and government will permit us. And none of them has acted, Milord. Now this Anchalik Panchayat and page 120 by the Deputy Commissioner, District Commissioner.
When did you apply pursuant to the order?
110, Milord. 110, this is to the Panchayat, page 110. And page 111 to the Principal Secretary.
Principal Secretary is yet to be considered. 30 days is over.
Over.
But why, Mr. Chaudhary, you are not attacking why the Mr. Pran Bora's client was running? Because that is, I made an observation.
Yes.
How it is possible? Because you cannot make a lease out a land
Yes.
or create any property without the permission of the government.
Considering my right, I have a private patta land. So it is to give me the permission, having regard to the, I mean,
And
ground-
your main problem was that
he was also competent.
only problem is the cattle which you have.
I have the 2021 Act.
Okay. Mr. PNRD. And PNRD is the one both. What is this type of applications you are doing? He has applied. You are to consider to grant or not to grant. But why you are rejecting it on the ground that doesn't have? We set aside this.
Yes.
Both these orders, because the order of the DC also seems to be something. He said he doesn't have a NOC. He's forgetting that he has applied. It is only his application is to be considered. I think you should consider. I allowed them to run. No, I never allowed them.
No, that permission was not there.
I've never.
Only
I'll-
time limit was there of 30 days.
I only gave Ram to 30 days. I only said, I never said it. No.
There is no
I
specific.
therefore thought immediately, what is wrong with me? I never passed this type of orders to run. Because that was the submission made on the date on when the hearing was there. So I said, no, nothing doing. Without compliance with law, it cannot be. But the fact remains this order is wrong. So we interfere with it and pass an order. We don't need the other people. Yeah. Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by, I'm doing it because again issuing a notice. New Year, I'm no more in bench 4. Issuing note. Heard Mr. So-and-so, the learned senior counsel appearing on behalf, assisted by so-and-so appearing on behalf of the petitioner. Mr. S. Dr. The learned standing counsel appears on behalf of the respondent number 1, 3, 3, 3,
1, 3, 5,
5,
and 8.
and 8. Mr. M. Sethi appears for the other respondents. Hey, Namkita Sailobo, by Gita. The petitioner herein has approached this court challenging the order dated 10/12/2025 issued by the respondent number 5 and comma the order dated 11/12/2025 issued by the respondent number 2 and also the delay in complying with the directions passed by this court in the judgment and order dated
24/9/25.
24/9/2025 in what is your name, Basumara? What is the name of the person?
9 of 25.
Abdul Majid. In
Sorry.
in WPC number 237/2025 and two other writ petitions. First, the issue so raised in the instant writ petition. Now, first off, this court have duly heard the learned counsels appearing on behalf of the petitioner, senior counsel, as well as Mr. S. Dutta, the learned standing counsel appearing on behalf of the PNRD. Taking into account that the issue involved primarily relates to a misconceived notion of the directions passed by this court in the judgment and order dated 24/9/2025, this court takes up the instant writ petition for final disposal at the motion stage. In the impugned judgment, in the judgment and order dated 24/9/2025, at paragraph number 45, the following directions were passed. Full stop.
Particularly in 5 and 7.
Full stop. At clause 5 of paragraph, at clause 5 of paragraph 49, this court directed the principal secretary to the government of Assam, Panchayat and Rural Development Department to consider as to whether the application so submitted by the petitioner dated 22/8/2024 under section 107 of the Act of 1994, seeking approval to run the private market can be granted or not. This court further directed the said authority to do so within a period of 30 days from the date the certified copy of the judgment is served upon the principal secretary to the government of Assam in the PNRD department. It is seen that on 9/10/2025 itself, the judge certified copy of the said judgment and order dated 24/9/2025 was served in the office to the Principal Secretary to the Government of Assam Panchayat and Rural Development Department. It is submitted by the learned senior counsel that till date, no steps have been taken in that regard. This court further finds it relevant to take note of clause 7 of paragraph 49, 45, whereby this court directed the petitioner to obtain prior approval from Katihara Gao Panchayat, that is the respondent number 7 in WPC number 237/2025, in terms with the mandate of section 107 of the Act of 1994. The petitioner thereupon requested the respondent number 8 for approval to run the private hut in terms with the liberty so granted in the judgment and order dated 24/9/2025. This was duly received on 7/10/2025. The record further reveals that the executive officer, Jolleswar Anchalik Panchayat, rejected the petitioner's claim, rejected the petitioner's request for permission on the ground that the petitioner hut does not have necessary permission from the panchayat for its operation. From the government/panchayat by the impugned communication dated 10/12/2025. It further surprises this court that it rejected the petitioner's permission to run the private market on the ground that the petitioner did not produce the no objection from the concerned Gaon Panchayat till date. From a perusal of both the orders passed by the respondent number 2 and respondent number 8, which are impugned in the instant proceedings, it appears that both the respondents have failed to take into consideration that the petitioners have sought for permission for running the private cattle market from the Gaon Panchayat as well as from the government, which was permitted by this court in the judgment and order dated 24/9/2025. the concerned authorities were yet to take a decision on the said aspect. But surprisingly, both the respondent number 2 and 8 have rejected the permission. Under such circumstances, it is therefore the opinion of this court that both the orders, that is, the communication dated 10/12/2000, both the communication, that is, it is that the communication dated 10/12/2025 issued by the respondent number 8 and the order dated 11/12/2025 by the respondent number 2 are required to be interfered with. This court also is of the opinion that necessary directions are also required to be passed, taking into account that there was a time limit prescribed by stipulated by this court in the judgment and order dated 24/9/2025. Accordingly, the writ petition stands disposed of with the following observations and directions. The communication dated 10/12/2025 issued by the respondent number 5, 8 no, 5 to the petitioner is set aside and quashed. Number 2, the order dated 11/12/2025 issued by the passed by the respondent number 2 is set aside and quashed. Number 3, the respondent number the principal secretary the respondent number 1 it is submitted that in the PNRD department there is no longer the post of principal secretary. Rather, the said post is now the functions thereof, the functions of the said authority now is being exercised. The power and functions of the said authority are now being exercised by the additional chief secretary to the government of Assam, Panchayat and Rural Development Department. Accordingly, this court therefore observes and directs that the directions so passed in paragraph number 45 of the judgment and order dated 24/9/2025 in WPC number so and so shall be read as directions to the additional chief secretary to the government of Assam, Panchayat and Rural Development Department, Assam. So accordingly, the said authority, who is the respondent number 1 in the instant proceeding, is directed to dispose of the representations so submitted by the petitioner within a period of 30 days from today. From the date a certified copy is served upon the said authority. This court further directs the respondent number 8 to expeditiously decide the application so submitted by the petitioner seeking permission in terms with section 107 of the Act of 1994. Accordingly, the writ petition stands disposed. At paragraph number 45, I pass some directions. The relief so sought for at prayer number B of the instant writ petition having already been redressed by providing the petitioners the medical records of their child till April 2025, no further directions are required, save and except that when the petitioner's child is discharged from the respondent number 1's hospital, all the up-to-date medical documents of the petitioner's child be provided to the petitioners by the respondent number 1. Insofar as the relief as sought for at prayer number C of the writ petition, nothing further survives, taking into account that the petitioners in person have duly submitted that they would not insist upon the prayer number C and if necessary approach the appropriate forum under the Consumer Protection Act 2019, if so advised. Taking into account the same, the petitioners herein are given the liberty to approach the appropriate forum under the Consumer Protection Act 2019, if so advised, and the observations made in the instant judgment shall not influence such proceedings. As the prayer number C is not insisted in the present writ petition, the prayer number D cannot further be acted upon. Further to that, the petitioners in person have duly submitted that during the course of the hearing on so-and-so, that they are not satisfied with the specialists offered by the state of Nagaland to carry out an inquiry, and they would like to take due opinion on medical negligence from specialists. Under such circumstances, no relief can be passed in respect to prayer number D. As there is no medical evidence produced which would show that there is any medical negligence on the part of the respondent number 1 hospital, its doctors and staff, the question of granting the relief at prayer number E and F does not arise. This court, further taking into account the order dated 18/2/2022 and 8/3/2022, wherein it was categorically observed as to the entitlement of the respondent would be decided at the later stages of the instant proceeding, grants liberty to the respondent number 1 to take action for recovery, if advised, by following the due procedure of law. However, this court finds it pertinent to observe that the respondent number 1, being a charitable non-profit organization and aim to afford good medical care to the needy people, as stated in their affidavit, may keep in mind the said aspect before initiating any recovery proceedings. This court further grants liberty to the respondent number 1 before initiating any proceedings to approach the state of Nagaland. The state of Nagaland, more particularly the respondent number 2 and 4, are directed to consider the request made by the respondent number 1, as apparently the respondent number 1 has continued the treatment of the petitioner's child for the entire period since her birth without any payment. As any amount paid by the state of Nagaland towards the dues of the respondent number 1 be set off as regards any claim of the respondent number 1 against the petitioners. This court further is of the opinion that the respondent number 1 cannot be further burdened to continue with the treatment of the petitioner's child without any payment, inasmuch as since the birth of the petitioner's child till date, the respondent number 1 have been providing treatment. It is also the opinion of this court that some cushion time be granted to the petitioner to make alternative arrangements. Accordingly, this court grants the petitioner a period of 30 days from today to make necessary alternative arrangements to continue with the treatment of the child, either at the respondent number 1's hospital or any other hospital. The respondent number 1 shall continue to provide the treatment presently administered to the petitioner's child for a period of 30 days from today, and thereupon, if the petitioners wish to continue with the treatment of their child at the respondent number 1's hospital, the same shall be subject to payment of the dues as per the terms and conditions of the respondent number 1 hospital. Liberty is granted to the respondent number 1 to recover the dues from the petitioner after complying with clause 6 herein above, and the period of limitation for recovery of the dues would start to run 45 days from today. This court further directs the state of Nagaland to carry out necessary negotiation with the respondent number 1 so that the amounts so claimed by the respondent number 1 from the petitioner can be reduced. This court further observes and directs that in the circumstance the petitioners are not capable of taking care of their child, the petitioner's child would come within the meaning of child in need of care and protection as defined in section 2(14) of the Juvenile Justice (Care and Protection of Child) Act 2015, and the Department of Social Welfare, Government of Nagaland, which is the department implementing the said Act of 2015, would be required to take steps in and do the needful. A copy of the instant judgment be provided to Ms. V. Sukroy, the learned Additional Advocate General, to inform the concerned department of the state of Nagaland for due compliance. You get the judgment?
Limited item 21 and one of production list.
Mr. Ibrahim,
Much obliged, sir. Much
I
obliged.
gave you continue the treatment for next 30 days.
Okay.
And
My-
thereupon it will be as per the terms. In the meantime, you can take up with the state government. The state government has also been asked to look into it. If in the circumstance you need to file any recovery proceeding, which obviously I think you should not. But anyways, if you do so, I'm not saying anything. But if you do so, then in that case, you can your period of limitation would start from 45 days.
Much obliged, my lord.
The petitioner herein which is given 30 days time in the meantime. In the meantime, the state of Nagaland, more particularly the Department of Social Welfare, has been directed to look into it if the petitioner's parents could take care of the child or not. If not, it is the bounden duty as per the Juvenile Justice Act to take the care of the petitioner child.
Much obliged.
Yes.
We're grateful to Dr. When we have seen the judgment, we should have.
Huh? Which one?
In terms of the judgment, we filed the IEM. There, I've read the judgment of the lordship. There in paragraph 41, they held that if the petition is by one of the constituents, he's a stranger. So it's not petition.
But therefore, I allowed this, I ask you to file that because this problem will happen later on
Right.
when you are filing it. Okay, others can leave.
Please,
please.
okay.
এই, কিছু বন্ধ আছে। Now, what is your case?
Now, Dr. will kindly see the NITs at page 35.
Hmm.
My lord, before my senior starts, my lord, there is an issue of maintainability, my lord.
Why?
If my lord will see the respondents at page number 4, the road project is.
But the problem is that yesterday only I asked him.
My lord.
Then you kindly come to page number, which one?
87, ma'am.
87. Wait.
No, lord.
Yeah. Yes. The bidding process shall be governed and construed in accordance with the laws of India. Courts of Guwahati shall have exclusive over all disputes arising under. So therefore, now.
Now, I notice inviting bid is at page 35. And also we'll see the estimated cost of the work is 429.94. And completion time is there, that is not relevant. Now, RFP I have annexed. Now, in the technical bid, the petitioner JV was responsive. In the financial bid, they have become L1, which your lot will find at page 196.
Where?
Page 196. Number 1 is the JV. They have quoted 2.27 crore money.
Page 196. What is the name of the petitioner?
The Messrs. Neeraj Cement Structurers Limited and Messrs. Satish Agarwal and Company JV.
Where is it?
First name of the petition.
Serial number?
1.
Neeraj. Okay, and so and so. So your amount quoted is 227 crores.
Yes.
Okay.
Now, my lord, page 201, what will see the first letter written by the Chief Engineer PWD Manipur to us, requesting us to give us justification for that. Page 201, para 2 is relevant. The evaluation committee observed that the amount quoted by the L1 bidder is so and so, which is 47.20% below the estimated cost of so and so put to tender, which is even below the ceiling of 20% as per clause 2.2.21.1 of RFP and the.
Then you gave justification.
Yes, justification we have given, which your lordship will find at page 240.
Then?
Primarily, I'm just indicating where it says 2 pages later.
primarily we have said that about 100 kilometers away from here, we are executing another work order for construction of road, and which is about to be completed. About 91% we have already completed. So we say that our man materials all are available. They are acquainted with the terrain, etc. So therefore, I am in a better position to execute at a lower price. Then they have issued page 248 letter at page 248 letter dated 19/9/2025, saying that you have to give item-wise details enclosed in annexure.
Okay. Then you have given that.
That also I have given at page, next page, page 249. And while giving that, I have indicated that I am executing a nearby, a similar work order in a nearby project manner. And they have now written at page 282 that kindly point out which is that project you are executing. Page 282.
Okay.
Now,
So they have now gone for a fresh tender.
yes, they have annulled it, page 328, what we will find.
Then,
My lord, so far as the annulment is concerned, my only submission before lordship is, my lord. The lordship will find it page 46. If the rate quoted is below even up to 50%, my lord, I have to give additional performance security, that is their RFP. Lord, we'll find it page 46, my lord.
clause,
Page 46, clause 1.2.7. Generally, the lowest bidder shall be selected bidder. In case such lowest bidder withdraws or is not selected for whatsoever reason, except the reason mentioned in clause so and so and so and so, the authority shall annul the bidding process and invite fresh bids.
what is 2.12?
Now, Lord will kindly see page 77. On page 77, clause 2.21 deals with performance security. Now, next page, page 70, page 78, Lord will find that there is a provision in case it exceeds 20%, I have to give additional performance security. Where the bid price is below 10%, but not below 20% of the subject cost put to bid, additional performance guarantee security percentage shall be increased by 0.1% for every percentage of bid price below 10% of the project cost put to bid, starting at 11% with the additional bid performance guarantee being 0.1%, and this additional performance guarantee percentage shall be applied on the bid price. Where the bid price is below is 20% or more below the project cost would be, the additional performance guarantee percentage shall be incremented by 0.2% for every percentage of bid price below 20% of the price cost put to bid in addition to 1% of the bid price. And this additional performance guarantee.
Where is this circular?
Now, circular is at page 150. 151. The circular and the madam at page 150, and the table shown at page 153 will make it clear that up to 50% it is permissible.
Where?
Page 153, madam. The table of you have seen, the first column is bid price of the bidder, second is performance bank guarantee, third is percentage discount to project cost put to bid. Now, I have given discount up to 47%. If it is 47%, then the performance percentage, additional performance guarantee will be 6.4%, 40%.
So you have to pay 6.40.
Minor. Now, if you
Additional
are also
performance
finding page
security
13
in
doesn't
rupees
need-
crores is 32.92. Total performance guarantee in crores is 49. PPG as per 1% cost is put to bid is 9.4%. So your submission is that yes, mine was 47.20% loss. Then you should have applied that particular formula whereby you should have given me a scope. But before that, there will be another clause, I suppose, somewhere that if they are not agreeable, then what happens? You see, normally, as I could see in those notifications also issued by the finance department, first is they will be asking for justification. If you are justified, then they are going to permit you to give additional security. It is not that if you quote 50% or 45% less will be given. There is no right on that, but that is subject to their subjective satisfaction in respect to whether you can be permitted or not. That must be some clause somewhere here. Isn't it? That is why they are asking for justification. Anyway, I think this is the case for issuance of notice and stay. Well, issue a notice and stay because this needs to be looked in. You come up. Chalo. Issue notice. Returnable on how much time? We're passing an interim order, so let us have it on 28th of January. Okay. In the meantime, they can also serve upon that year from Manipur. 28/1/2026. Mr. H. Gupta accepts notice on behalf of respondent numbers 1, 2, 3. Extra copies of the writ petition be served upon him during the course of the day. As regards the respondent numbers 4 to 7, the petitioner is directed to take steps by tomorrow through speed post. In addition to that, the petitioner is also directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner shall ensure that the service of dusty is meted out upon the respondent numbers 4 to 7 on or before 31/12/2025. The petitioner herein is aggrieved by the cancellation of the tender process and the initiation of a fresh tender process by the corrigendum dated
8/12/25,
8/12/2025.
page 328.
First stop. It is the case of the petitioner that the petitioner was technically found that in pursuance to a notice inviting tender issued by the chief engineer, by the chief engineer, bracket Northeast, by the respondent number 2, dated 23/5/2025, the petitioner, along with various other bidders, participated in the said bid. The petitioner's bid was found to be technically competent. Pursuant thereto, the financial evaluation was carried out, wherein it was found that the petitioner was the lowest bidder, having quoted 227 crores as against the bid value the estimated cost of rupees 429.9 crores, which is 47.20 below the estimated cost. The petitioner was asked, pursuant thereto, the petitioner was the respondent number 5 had issued a communication to the petitioner asking the petitioner for the purpose of petitioners for the purpose of giving justification. The petitioner gave justification. The petitioner gave justification to the justification on the in pursuance to the communication dated 4/9/2025. Subsequent thereto, the respondent authorities again sought for further justification, which the petitioner have also duly provided. However, without any rhyme or reason, the entire tender process was cancelled and a fresh tender was sought to be initiated or by the corrigendum dated 8/12/2025. The learned senior counsel appearing on behalf of the petitioner drew the attention of this court to clause
Annulment is 1.2.7846. Two point two one, 4.62 at page 7.
where is that 2 point?
2.21. 2.21 at page 77. Performance given.
To clause 2.21.1 and submitted that it is very much permissible to give to have quoted permissible to quote even below to quote below 50% of the estimated cost. And the only thing which the respondent authorities ought to have taken into consideration is that there would result in payment of depositing of further additional security. In that regard, the petitioner also referred to the circular dated 30/4/2025, where the details have been provided as to how the additional security in such circumstances can be directed to be directed. The learned senior counsel appearing on behalf of the petitioner submitted that the respondent authority, the rejection of the justification and calling for a fresh tender without passing any reasoned order makes the action on the part of the respondent authorities unfair and unreasonable, for which this court may exercise its jurisdiction under Article 2 to 6 of the Constitution. The learned senior counsel further submitted that in pursuance to the corrigendum dated 8/12/2025, steps are being taken for issuance of a fresh tender, which would result in multiplicity of further proceedings if the impugned corrigendum dated 8/12/2025 is not stayed pending the next date. Mr. H. Gupta, the learned CGC, who represents the respondent numbers 1, 2, and 3, submitted that he would like to obtain instructions as regards as to whether there were justifications provided. He further submitted that the tender in question pertains to widening and improvement of roads. And if there is any interim order passed, it would delay it would hamper the public interest. Full stop. This court had given an anxious consideration to the respective contentions made by the learned counsels appearing on behalf of the parties. The materials on record suggest that up to 50%, that a bidder can quote up to 50% below the estimated cost. And in such circumstances, the only question which arises, and in such circumstances, the bidder has to pay additional security. Additional performance guarantee. Full stop. It is not known, and the materials on record do not show as to why the justifications which was given by the petitioner was rejected. Full stop. Considering the above, it is the opinion of this court, prima facie opinion of this court, that the impugned corrigendum dated 8/12/2025 appears to be contrary to the terms and conditions of the contract, as well as the circular dated 30/4/2025 issued by the respondent number 1. Accordingly, this court therefore directs, in the interim, that states the impugned corrigendum dated number 4 dated 8/12/2025 issued by the respondent number 1 till the next date. Full stop.
The subsequent letter also on similar line, page 331, 16/12/25, says again that shortly the bids will be invited.
Where?
Page,
You have not challenged it.
this is the same.
You have not challenged it. Have you challenged it?
The prayer I have not mentioned, but the subsequent communication, because we filed submitted representation. They have not said anything new. They are just confirming that fresh bid shall be invited for.
And all consequential actions in pursuant state. This is an application filed by the petitioner, applicant, to implead this is an application filed by the petitioner to implead the applicant number 2 and 3 to implead the petitioner JV partner as well as the joint venture as petitioners to the instant writ petition. Full taking into account that the presence of the partner, JV partner of the petitioner, as well as the joint venture is necessary for the proper adjudication of the instant dispute, comma, this court impledes the applicant number 2 and 3 as petitioner number 2 and 3 to the accompanying writ petition. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court by tomorrow. Yes. By tomorrow. And registry shall make necessary changes in the cost title and also update the same in the CIS. I stands disposed.
My technical bid has been rejected.
Huh?
My technical bid has been rejected on the ground that the IP address, my IP address along with two other bidders are the same. You will find the notice at page 47.
Where is the impugn order?
247. Purportedly for violation of section 21B of Integrity Act.
Then
By mere similarity of the IP address, they are trying to say that there is a curtilation attempt over. But these particular.
Then did you file a review?
Lodge.
What happened?
I have filed a review. They have affirmed to their the things at page 250 is the order.
Huh?
My application is at page 248 for review.
But this is too late.
They have considered. They have considered this.
Then
Then the order at page 250 has been passed. They have affirmed to the extent whatever we expected.
Then
Now we find that the particular clause which speaks of the curtilation.
then you have been issued a show cause.
Now, thereafter they have issued a so-called, so far as my EMD is concerned, that has been encashed. And now issued the so-called notice, as page 251, as under their banning policy, why I should not be debarred from participating in the tender process, etc., etc.
Now you are against what?
But I am against the order, the letter dated 2/9, so far as rejection of my bid, encashment of the consequential encashment of the BT, and against this so-called notice.
Why should I interfere?
But firstly, this finding.
So cause notice you have to submit your reply.
That because that is a consequential which has come up from this their.
Your technical bid was rejected. Then 4/9. Then it was
No, so far
first you were supposed to submit the review within 4 days. You file after 38 days.
So far the tender has been finalized. I am not on the under tender process.
So then the technical bid rejection is for what?
So far the encashment of my the bank guarantee. So substantial amount.
How much?
It's 29 lakhs 50,000.
But there is no stay. There is the encashment has already been done.
Already been done, Lordship.
It's okay.
I'm sitting state of.
Only on that we'll issue notice, but I'm not going to entertain this petition on the other grounds. On the ground of rejection of the technical bid, no. on the ground of this, but only on the question. The only limited question in the writ petition is as to whether there was any violation of the Integrity Pact, one. And secondly, it is only if that is the question, then only encashment will happen.
Yes.
But not on the rejection of the technique because you have come too late. And the so-called proceedings, you have to reply.
This aspect, cartilation, that particular in the clause of the integrity pact, it doesn't speak of that the cartilation would include this if the IP addresses are sent. Let's kindly look into the that particular clause 211. So, Mayor, my lord, I have replied that it is coincidence.
IP address belong to whom?
My lord,
IP address belong to whom?
it's in my reply. It's a coincidence. Someone else also had submitted tender therefrom. So it's a coincidence. And merely, this IP address is same without opening the price bid. Price bid has never been opened. Cartelation, even though this cartel has not been defined in the tender, but it will also takes into the definition of the Competition Act. But there has to be an agreement to control the market or to restrict the competitiveness of the bidding process, etc. The Apex Code also, because this Hindustan Development Corporation of 1993, after discussing this, the meaning of this cartel, it's clearly laid down that mere one component, that is the price is similar, that amount to cartelation or cartelling. No so-called nothing was given prior to this rejection of the bid on that ground. No clarification was sought for from. And there is no other ground that you have seen the notice. Only that the IP addresses along with the two other tenders are same. There has to be an agreement, something more than one aspect, but not merely the price is same or the IP address is same. Something more is there that there were some agreement among the bidders to restrict the competitiveness of the bidding process. And exactly on this similar point, the Bombay High Court has clearly said that cannot the similarity of IP address alone cannot be assumed to be cartelation. You may have a suspicion of cartelation, but cannot be substituted to be a proof along with that.
When are you to reply?
Reply within 15 days.
Huh?
Within 15 days.
Time is there.
Lordship, otherwise
Within 15 days.
otherwise NOA is already been issued, Lordship.
No, we are not ensuring that. He's also not contesting that. His only thing is the remark in rejection of the technical bid
Lordship.
is going to have a far-reaching consequences in many other aspects.
Lordship, in that
That
aspect,
there is a integrity pact being violated
Lordship.
has a far-reaching consequences whenever the petitioner applies for any contract.
Lordship.
So he's on that aspect.
Lordship.
And the consequential action for termination, issuance of show cause. Show cause, he will reply to that.
Lordship.
But as regards that aspect, this court shall consider at a later stage.
Lordship. Lordship,
There's no
at this
question of
stage-
stay now. Let him submit a reply
Lordship.
to that. Show cause proceedings, this court cannot look into that now. Chalo. Issue notice making it returnable on 21st of January 2025. Mr. P. Buru accepts notice on behalf of all the respondents. The petitioner herein is agreed by the rejection of its technical bid by the communication dated 2/9/2025, isn't it? 2/9/2025. On the ground that the petitioner had violated clause 2.1 bracket B of the Integrity Pact, bracket understanding between petitioners in an attempt, bidders in an attempt to restrict competitiveness or introduce cartelization of bids. The petitioner is further agreed that upon rejection of the petitioner's technical bid, the respondent authorities have also issued a show cause notice on 8/12/2025, thereby initiating a process for blacklisting the petitioner. Mr. P.J. Saikia, the learned senior counsel appearing on behalf of the petitioner, submits that the petitioner is not going to contest as regards that rejection of the technical bid for the contract. But however, the petitioner would contest the communication, would contest the email dated 2/9/2025, whereby the petitioner's bid have been rejected on an absolutely untenable ground, that is, the petitioner had violated clause section 2.1b of the Integrity Pact. The learned counsel appearing on behalf of the petitioner submits that the allegation, as would be seen from the show cause notice dated 8/12/2025, would show that the petitioner, that both the petitioner and another have used the same IP address. The learned senior counsel submits that the IP address was in respect to a cyber cafe, which the petitioner had used for uploading his bid. The petitioner is not aware about the other gentleman, other bidder, who have also used the same IP address. In that regard, the learned counsel have also referred to the judgment of the Bombay High Court in the case of MSSK Translines Private Limited versus the Maharashtra State Warehousing Corporation Limited. Dated 11/7/2016, wherein the Bombay High Court, the division bench, learned division bench of the Bombay High Court observed, had observed that mere using of the IP address, the same IP address, cannot result in formation of a cartel. Full-stop. This court have also heard Mr. P. Borua, the learned counsel appearing on behalf of the petitioner, respondents, who submitted that in the meantime, the LOI has already been issued in respect to the tender in question. The learned counsel for the respondents also submitted that the question as to whether there is a violation of the Integrity Pact can be decided in the said show cause proceedings, as it is a question of fact which cannot be adjudicated in the instant proceedings. First, the learned counsel submits that the jurisdiction of this court, as per the settled principles of law, is only to see the decision-making process. This court have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the respective, have heard the learned counsels appearing on behalf of the parties on the question as to whether interim directions are required to be passed. The petitioner herein is not contesting the rejection of its petitioner's technical bid or the tender in question. But the petitioner herein is contesting the reason why the technical bid was rejected, inasmuch as it is the case of the petitioner that no case of violation of clause 2.1b of the Integrity Pact arises. It is also seen that the respondent authorities have, on a review being sought for by the petitioner, again rejected the said aspect. Whether the rejection has been proper or not, this court shall consider during the at the later stages of the instant proceedings. The question now arises is as regards the show cause notice. It is the opinion of this court that the petitioner, that at this stage for this court to interfere in the said proceedings would not be proper. However, it is observed that some limited interim directions are required to be passed. Accordingly, this court passes the following interim directions. Number one, the petitioner herein is given the liberty to submit the show cause reply to the proceedings initiated on the basis of the show cause notice dated 8/12/2025. The respondents, if the petitioner seeks for a personal hearing, the respondent authority shall provide such personal hearing. Liberty is further given to the respondents to take a decision in the said show cause proceedings. However, the said decision shall not be implemented without the leave of the court.
Much agree.
What is this IA? Caveat discharge. What is this?
Petitioner was otherwise technically qualified. His technical bid was rejected on the count of non-compliance of a condition which was mentioned in the checklist. Mentioned in the checklist, not the tender document of the tender. Now, subsequently, the work orders are also issued, and the petitioner had filed 2 representations, to show that the other tenderers who were allotted the work, they have misrepresented the authorities. That is the case in a nutshell, may kindly, because with regard to the first contention, the checklist or an appendix.
Was that not the only contention? How many contentions you have?
The checklist cannot introduce a new eligibility criteria. It's a 2-bit tender process, may come to the NIT, starts from page 21 for a moment. The entire tender document is divided into 3 parts, Section 1, which is the ITB, Section 2, the qualification information, Section 3, the conditions of contract. Now, if directly comes to
yes,
page 36 for a moment, what are the requirements, technical requirements that has been stated? 36. My lord has it. C, preparation of bids, technical bid. The technical bid to be submitted by the bidder shall comprise of A to P, my lords. It enumerates, my lords, 16 conditions, my lords, which
What?
has to
32.
30, page 36, my lord, page 36. C, preparation of bids, A, technical bid, my lords. The
Okay.
technical bid to be submitted by the bidder shall comprise of such and such. Now, my lord, the condition, my lord, the determination of responsiveness that is provided in page 43, my lord, for clause 26, page 40.
Show me that impugn order.
Yes, impugn order, my lord, would come to page 79, my lord. Page 79, the relevant portion at page 80, my lords. There were 4 tenderers. The name of the petitioner is Puran Kumar Mohanto.
Who are
Whether
you?
qualified in technical bid? No. The reason, my lord, bidder has not submitted the proof of ownership of lease rent equipment along with the lease rent agreement duly notarized on a non-judicial stamp paper of ₹50 as per point number 16 of the appendix checklist of the bid document.
Hmm.
That is not an essential requirement, my lord. I'm otherwise, as per the technical bid, my lord, I'm responsive. Now, a new clause has been introduced in the appendix, which is not part of the bid document, my lord. It's part of the bid document, my lord, but index confirm.
Why the lease the agreement is required?
My lord, for the purpose of
Of
the
the
work,
lease require rent equipment along with the lease agreement. Proof of lease. What is the contract for?
the contract
Two
is for, my lord,
numbers of
installation
emptiness
two
scheme
number
and
of
so and so.
MPTW, which is, my lord, micro drainage tube wells, my lord. Irrigation department, it's for installation of tube wells.
Where's the checklist?
Checklist is, my lord, that page,
Kindly see page
clause
55.
55 minutes. Now, my lord, may kindly tally the checklist. It starts from page 54 with page 36, the technical bit. All the other enumerations are same, my lords, except point number 16, which does not find place, my lords, in the technical bit. No, they could not have rejected my bid for non-compliance of a provision contained in the checklist.
Rejected. Next.
Now, the next, my lord,
Then others also did not submit.
my lord,
Others also did not submit.
others also did not, no, they submitted, my lord. The other two bidders who were qualified were issued work orders, my lord. The first bidder, my lord, respondent number 7, he had submitted those affidavits for which my bid was rejected, my lord. Now, my lord, kindly come to page 99 for a moment, my lord. He had given 4 vehicles, my lord. He had shown 4 lease deeds for 4 vehicles. Page 99. This is just one lease agreement. I have appended all the 4, my lords. Now, this is the lease deed for a vehicle, which, my lord, the description, my lord, would find at page 101. The registration number is there, my lord. See? It's registered as AS25BC 6693. Now, my lord, may kindly come to page 111.
Now, did you comply with 17? Clause 17 or not?
Yes, the only allegation is.
No, did you comply? Then, therefore, the documentary proof. Where is your second submission? The first is rejected. Now come to the second.
The second, my lords, the respondent number 7 has submitted documents as provided by clause number 16, my lords. He has provided 4 sale lease deeds, my lords, for vehicles. But all the vehicles, my lords, the fitness has expired, my lords. They're not fit for flying on the roads, my lords. It has been misrepresented. There's a clause in the tender, my lords. If you misrepresent, your tender is liable to be cancelled.
Did you inform them?
Yes, I have filed 2 representations, my lord, not acted upon. My lord would come to.
But what do you say about Ronak? Ronak says an ineligible bidder cannot challenge a LOI. How do you take care of that?
Yes, my lord, the prayer are twofold, my lord. First, my own rejection is put to challenge, my lord, because.
Rightly so.
Yes,
Rejected.
because, my lord, Checklist. cannot include
When the work order has been issued?
Work order, I don't have the exact date.
As per my instruction, 18/11, Lordship. This is a 3 months completion, Lordship.
You have not
period.
challenged the work order?
I have challenged the work order, the work orders were not there, so the
Not challenged.
details of the work orders are not there in the prayer, but I have challenged the work orders issue.
We do one thing, file a additional affidavit and have it after vacation. We
In the
get a
meantime,
better
Lordship,
chance.
in fact, Lordship, the technical bid was rejected on 14/11/25, Lordship. He has come to the High Court, Lordship, filing the petition only on yesterday, Lordship.
14/11 yesterday. final.
Mr. Mohanto, I don't want to dismiss your petition today. So better off, I'll say that he says that a work order has been issued. Do you have a copy?
So Lordship,
Do you have the copy?
Provides a copy. Madam.
You'll provide a
can
copy, he will file an additional.
Final done.
That is a better option today, for today.
Madam. Deeply obliged.
in fact, Lordship, the work in
Mr. Enupai Delaland Council, who appears on behalf of the Irrigation Department, submits that the technical bid was rejected as far back as on 14/11/2025. And thereupon, the work order has been issued on 18/11/2025. Mr. P. Mohanto, the Learned Counsel, appearing on behalf of the petitioner, submits that though the petitioner have challenged all consequential actions, however, the petitioner do not have a copy of the work orders. Now, taking into account the said submission, this code directs the Irrigation Department of the Government of Assam to provide the petitioner the work orders in question, so that the petitioner can file an additional affidavit challenging the same by filing so that the petitioner can file additional pleadings. List this matter on 9/1/2026, the work orders be provided to Mr. P. Mohanto on or before 31/12/2025.
Deeply obliged.
obliged.
The petitioner is against the suspension order of his seriousness issue order. Pursuant to the Sobos notice. Kindly look at page 31. The Sobos is issued on matter 16/12/25. Give me 7 days time to file reply. Page 31. These are issued by the 4 district commissioner to go.
So was notice and suspension.
On immediate next day suspension. Against my license is
Who has done it?
co-district commissioner.
Why?
So malpractice even so was notice, I have given 7 days time.
Where is the order?
Order page 32.
It has been reported to the undersigned that so and so has violated the following terms and conditions of the order of Iman. In view of the above violation, the exercise of the powers under so and so stands suspended until further orders. What is this power under 11.1 and 11.2?
That is awarded by the central government matter. Order under 2000 or liquefied petroleum gas regulations. Order under 2000. Just
What is this 11.1 and 11.2?
Assam trade articles licensing.
So what is your case?
Number one matter. Then assign matter. Violation of necessary matter. 7 days time has been provided to me.
For show suspension.
Suspension. Sogo's notice was issued.
This is done under what provision?
On the 6th.
This is being done under the Assam Trade Articles Licensing Order.
They
Okay.
cannot, man. They cannot.
Ah.
But they have the power only to seize matter and inspect matter. Any penal action matter has to be taken by the oil.
Oil. Are they not your distributor?
That's been the expected by both. Similar cases, this court has disposed of similar matter.
Where?
Oil had submitted that matter, the authority has no right. That is page 13 number. Can you have it? Page 39. Paragraph 10. The submission submitted by the oil. These are similar case.
Where?
Page 39, paragraph 7.
That is a submission.
There is a
Where is the finding?
page 22, paragraph 22, page 42.
Okay, paragraph 22. Mr. Khonigar. We set aside. So-called proceedings and order has to be set aside. This
Yes,
cannot be
sir.
done.
Because immediately on the next day, it was suspended. Immediately after.
No, whatever may be,
Yes.
you don't have the power to pass this
Yes,
order. We set aside. Huh? Heard Mr. A. Khonigar, the learned counsel appearing on behalf of the petitioner. Mr. M. Sethi accepts note, appears on behalf of the respondent numbers 1 to 5. Mr. M. Sharma appears for respondent number 6. The petitioner herein is aggrieved by the actions of the respondent number 4 in issuance of a show cause proceedings by the communication dated 16/12/2025, as well as the order dated 17/12/2025, whereby the petitioner whereby the license of the petitioner bearing license number DS-1-B /ATA/R/2001-06 PT-1/7 was suspended until further orders. The learned counsel appearing on behalf of the petitioner submitted that the power so exercised by the respondent number 4 is absolutely without jurisdiction and authority, inasmuch as the said power at best could have been exercised by the sales officer of the Indian Oil Corporation and not by the respondent number 4. The learned counsel further submitted that in terms with the Assam Trade Articles bracket licensing and orders control bracket order 1982, the limited power available upon an officer duly authorized under that order is to carry out search, is to carry out entry, search and seizure, and nothing beyond that. Full stop. This court have also heard the learned counsels appearing on behalf of the respondents insofar as the authority of the respondent number 4 to issue the show cause proceedings as well as the dated 16/12/2025 as well as the order dated 17/12/2025. Full stop. It has been drawn, attention of this court have been drawn to a judgment of the coordinate bench dated 17/9/2018 in WPC number 2727/2018, wherein the learned coordinate bench have duly decided the said issue. Full stop. Paragraph 20 to 22 of the said judgment being relevant is reproduced herein under page 44. From the above quoted observations made by the learned coordinate bench of this court, it is apparent that the power of the respondent number 4 at best could be of entry, search, and seizure, and not to initiate any action for suspension or cancellation of the license. Full stop. Consequently, therefore, the court sets aside the impugned order, disposes of the instant petition with the following observations and directions. The order dated 17/12/2025 issued by the respondent number 4, thereby suspending the license of the petitioner bearing license number DS-DS1-B/ATA/2001-06/PT-1/7 stands set aside and quashed. Number 2, the so cause proceedings so initiated by the respondent number 4 by the so dated 16/12/2025 for cancellation of the license of the petitioner is also set aside and quashed. You are waiting for what matter?
Famous Muslim Ali.
Ali.
Or lots of can have it after vacation.
Is there any urgency?
Urgency, on last occasion, Lordship has directed me to have the instruction, whether the leftover portion, whether we have already.
That one.
It is pending, my lord.
Prepared to do at the old rate.
Lordship will record that part, my lord, and I will have the instruction whether they are willing to give it to the petitioner for the,
And
at the
provided-
same rate of 2014.
Huh?
At the same rate of 2014,
Please
because,
rate.
yes,
And my lord, provided they pay us the pending RFs.
that is not there in the prayer otherwise.
This
In-
there.
No,
The other writ petition is pending on that.
no, on this.
Or better lordship have this matter with 3793 meter. There's another writ petition where we have prayed for preparation of the estimate for the.
Yes.
My lord will show we have done extra work and they paid also. Let it come along with 3793 of 22 meter.
Yes, Lordship will only indicate that, my lord, in the meantime, I will have the instruction whether they will be allotting it to the.
Yes, we are prepared
Only on
to
that.
do at the old rate.
Record their statement that, my lord, they are prepared, my lord, are willing to do it at their old rate.
This court, by an order dated 15/12/2025, sought instructions from Mr. B. Gogoi, the learned standing counsel of the PWD, as to whether the remaining work has been allotted to some other agency, and further whether the work still remains to be completed. In that regard, an instruction has been placed before this court by Mr. B. Gogoi, the learned standing counsel of the PWD, wherein yeah,
In the next page, my lord, in the chart.
dated
In the remarks part, it has been mentioned.
dated 16/12/2025. The said instruction is kept on record and marked with the letter X. From the said instruction, it is apparent
In the remarks follow.
that initiation of fresh NIT for balance work is under process at the office of the Chief Engineer PWD Building, bracket Health and Education Assam, Chanmari. Full stop. The said instruction therefore shows that till date, the remaining portion of the work have not been allotted to any other agency. Full stop. Mr. Kane Chaudhary, the learned senior counsel, upon instructions from his assisting counsel, submits that the petitioner herein is willing to carry out the said remaining work at the old rate at which the petitioner was allotted the contract. Subject, however, that the petitioners, the respondents, clear their pending RA bills. Mr. B. Gogoi, the learned standing counsel of the PWD, submits that he would obtain instructions in that regard. List the matter when
My lord, immediately on the reopening, because it is pending from 2023. ma'am. Any day,
Along with WPC 3793.
on 7,
lordship.
7/1/2026, along with
22.
WPC number
3793 of 22. Deep look.
It is no more my headache now. I won't be taking up this bench.
I think we'll have to say a day for the year. It's the last matter. Deep look.
No, that is why, Mr. Chaudhary, in the motion only I finished up that matter.
Right.
Otherwise, if I stay it, you will be always for all times to come. It will. Yes, Mr. Hawk, your unlisted is a very dangerous non.
My lord, here, my lord, the petitioner was technical qualified, my lord.
Which department?
Well, PWD.
Oh, PWD. Where is the PWD gone? Mr. He was there, na? He's gone.
He knows also.
You are PWD. Mr. B. Gogoi. Your motion.
My lord, against my lord, there are two works, my lord. Against one work, my lord, they have already issued LOA, my lord. Finance bid after opening this finance bid, my lord. But in the instant case, my lord, that finance bid has not yet been analyzed, my lord. Sir, my lord, fixture status, my lord, page number 48, my lord.
You are the?
My lord, I am the Deepak Sharma, my lord. Again, page number on page 50, my lord.
Package number 1.
Package number 1.
So you are technically competent.
Yes, my lord.
Now what happened?
Now, my lord, no financial bid has been open, finalized, my lord, against this package, my lord. Whereas, my lord, the serial number 2, my lord, that I have supplied a copy, my lord, that has already been, LOA has been issued, my lord. What my limited time, my lord, that.
What is the urgency today to move?
Yes.
Huh?
The vacation is coming, my lord.
Itu কি? Itu নেকি?
Technical bit ক'ত আছে?
Itu হৈ গ'ল এইটো.
এইটোতো বেলেগটো।
নাই নাই সেইটো আমি qualify
Okay.
কৰিছো।
ক'ত আনো?
Issue notice making it returnable on 7/1/2026. Mr. B. Gogoi accepts notice on behalf of respondent numbers 1, 2, and 3. Extra copies of the writ petition be furnished to him but during the course of the day. The petitioner herein participated in pursuance to a detailed notice inviting tender dated 17/10/2025 in respect to which one? Serial number 1 or 2?
One man.
In respect to serial number 1 of page 15 of Jumkini Dia Setu. Huh? Full stop. In the technical evaluation carried out on 25/11/2025, it was found that the petitioner along with two others were technically competent. Full stop. The grievance of the petitioner herein is the financial bid have not been opened. Although in respect to the second work, the work at serial number 2 of the detailed notice inviting tender, not only the financial bid have been opened, but also letter of acceptance has also been issued. Full stop. Mr. B. Gogoi, the learned standing counsel for the for the PWD department shall apprise this court on the next date as to why the financial bid have not yet been opened, and if opened, shall apprise this court as to whether the financial bid has been opened or not, and if not, the reasons therefore.
The pendency shall not be a bar, my lord, to proceed.
Full stop. It is observed that pendency of the instant disposition, however, shall not preclude the respondent authorities to proceed to evaluate the financial bid and proceed with the tender process.
I'm okay.
And bring to a close the tender evaluation process.
Public.
Yes, Mr. Bora, your matter.
My lord, within 6/2025, the Assam Seed Corporation, the NIT, for procurement of various seeds. We are concerned with one variety hybrid maize seeds, and the requirement was about 3,000 quintals. Now, bidder can either be a producer or a dealer of a manufacturer. That your lordship will find at page 27. The bidder shall be one of the following class of entities to be eligible to participate in a bid: seed producing company, firm, or authorized dealer or distributor of seed producing company. I fall in that. Important note, my lord. That is all right, my lord. Then if your lordship sees the authorization at 31, 30 and 31, manufacturer's authorization, one of the documents that is required to be supplied along with the bid document is a manufacturer's authorized letter, my lord. And that will, the format your lordship will find at 63. In terms of the format, the manufacturer has issued an authorization to me on 30/7/2025. The lordship will find that at page 141 in terms of the requirement of the tender process.
Right.
My lord. The manufacturer is, my lords, producer's authorization letter. Shriram Bioseed Genetic, a division of DPM Shriram, who are the producers of basal seeds or tofu, having processing plants at Telangana, do hereby authorize MS Garg Enterprise, that is me, to submit a bid for the purpose of which is to provide the following truthful label seed produced by us and subsequently negotiate and.
Now, what is the reason why you have
I am
filed?
showing because the quantity, authorized quantity is
It's the,
1,500 quintals. Your lordship would just mark that.
1,000 and 1,500.
1,500 quintals. So they gave the authority in terms of the tender, and an agreement was also signed at page 142 between us. And this is what, because this format is part of the tender document, you're required to. And your lordship would see at 141, we stand guarantor at page 141. And what's that?
This is as per the format.
Format.
Yeah.
Now at 104, if your lordship sees, I am L1. It's 17, serial number 17, if your lordship sees. Garg Enterprise, my lord, has at 104. 17 Garg Enterprise. The product is hybrid genes maize bio 605. Quantity 1500. My offer. is
Wait,
30.
wait,
Serial
104.
number 17, my lord. Page 104.
Yes.
My lord has that. 17 is relating to hybrid male, and 17 is the petitioner, girl. The lordship would see quantity is also 1500. 35,100, I am L1. My lord has that. 18 and 19 are respondents 6 and 7. They are L2, L3. So I was L1, they are L2, L3. The government writes to the corporation and we require about 360 odd quintals at the moment. That your lordship will find that at 111.
Is it
But-
something like a rate contract?
My lord.
Is it something like a rate contract or no? Okay. No, because we are quoting for 1500.
1500.
So what is the tender for then?
Tender was your lordship, they said maximum could be 3,000, but the discretion is there on the buyer to reduce or increase the supply.
No, let's see the tender. What is the tender for?
Tender is at the requirement your lordship will find at page 54. My lord has that, details of requirement, page
Be
54.
system for supply of hybrid.
We are concerned with, my lord, two hybrid maize, 3,000. But they say that, note, if your lordship doesn't guarantee procurement of minimum quantity, the buyer shall have the sole and unfettered.
How will they choose first?
My lord,
How will they choose?
that is at page 43, my lord. They should, the precedent should be given to L1. 44 if your lordship sees. 2.3.1, 331. Subject to ITP 3.2.1 that your lordship will find at the previous page where as always, they have the discretion to accept or reject. But 2.331 if your lordship sees, subject to ITP 3.3.2.1, the contract shall be awarded against each of the variety of the crops as mentioned in the bid separately. to
3
the
point?
Lowest,
3 point?
my lord.
Evaluation of comparison
Page
of the bids.
44, my lord. 44, award of contract, page 44.
Valuation of the. Ah. Contract shall be awarded against each of the variety of crops as mentioned in the bids separately to the lowest responsible owner for the said variety following the least cost basis selection. Financial evaluation so and so. ASL reserves the right to award to more than one bidder in case full required tender quantity is not fulfilled to L1 bidder. Rest required quantity will be fulfilled through the So they will therefore find a least cost basis first.
L1 should be given the thing, but what happens now is this, my lords. Against I was L1, government said now procure 367. I was allotted only 50 quintals. And the remaining 300 are now divided between the L2 and L3 at my rates. And the reason is this, my lords. That is why I was showing your lordship the manufacturer's authorization becomes critical because it's part of the tender process. Because he has now, pursuant to these authorization which he is required to give him at a relevant time, he appears to have written directly to the corporation that so far as the petitioner is concerned, we will only, because ultimate supply will come from them, we confine it to 50 quintals.
Who, your producer?
Yes, Shriram.
Then?
That is why the impugned orders your lordship would find, first 126 at 127. He has come to an agreement with R6, R7 126, this is the allotment letter to me.
Hmm.
1500 original quantity, responsive, I am L1.
Hmm.
Garg Enterprise, please arrange to supply hybrid maize seeds bio 607 as per specification and terms condition mentioned in annexure 1 and 2 as enclosed herewith. Please note that the supply will be governed by terms and conditions of the tender floated so and so, which has been accepted and submitted by you along with the order. And if your lordship sees the next page, so far I am concerned, the quantity is restricted, your lordship has 127. 127, I am restricted to 50 quintals. Now, at 129, Amara is the, my lords, are L2, 129. So your lordship will see at 130.
Where is that letter written by that girl, by your Sriram?
That letter we don't have, but I have. You have.
I am from the seat corporation. I have the letter, Lordship.
So it is a fight between you and your principal.
That is right. That is right. That's, there is an element of.
There is a violation of the agreement by him.
See, my lord, what falls from your lordship, but that is why I was showing the.
In fact, they are giving it to somebody else more. Amara and Khan brothers,
And our R6, L2, L3.
they are
So
given.
there is
Yeah.
some agreement between R6, your lordship would see, they after giving a
So
guarantee.
how can you now, how if your producer is going to give you 50?
That is why the annexure becomes important. That letter is in terms of the annexure of the tender process, where you give a guarantee so that I can use it to the.
So are you therefore not trying to
He has committed.
take a step against that private respondent? It will be a private respondent or a private party.
Absolutely right.
So why should this court entertain this?
Absolutely right. Only thing is that now Steel Corporation has also, if there is, in terms of the tender, I am supposed to give the authorization letter.
If the you want the seat corporation to take action against Sriram, then
There is why should they accept the sanctity of the letter which was provided and furnished at the relevant time? The tender required an authorization
but
from the manufacturer.
but Mr. Goswami, the most pertinent problem here is this.
Whether
If your producer says that I'm going to give you 50, if they give you 100 also and you are not able to supply, you will be blacklisted. You will be blacklisted.
That is true, man. There is that problem of whether a writ will.
And therefore, I say that it is something form of a rate contract, which you find it in Rule 24, 1, Rule 24, I1 of the procurement rules. So here they are going to therefore find out this the least price, the lowest price. And thereupon it will be given down. Here the preference or incentive is so much given that the lowest bidder will be given the entire quantity. If it cannot be fulfilled, it will be gone to L1, L2, L3.
Tender clauses are also formed.
So this is how it is being done. Now, your person who is giving the authorization, he has backstabbed you.
The whole issue is with the corporation without at least a notice given to me, whether I was in a position to get this supply from some other authority or company. At least.
Why don't you fight it out with Sriram?
That is true, Mata. That is true.
That is the only way out. And then ask them again to revoke this.
The only thing is whether your lordship would consider entertaining private parties very difficult unless Praga 2 onwards, there's element of statutory or public duty involved. Here only thing I can say is this, that the requirement of tender by which they also have come into the process.
They can very well take an action against Garv, Sriram.
But they are also seems to be happy with
But they seem to be happy.
They are also.
Happy with them.
They are giving allotment in terms of Sriram. So
Ah.
it appears all of them have.
All have gone against you. Very difficult. Because if I say not to allow the others, there will be a dearth of seeds. That is again affecting the public.
They negotiate with me. Why should they negotiate with L2, L3 instead of L1? If at all they have to
But the
negotiate.
guarantee which is there
If they have
is only
received
to
if they
50
have
now.
received a letter like this, the first thing they should write to me saying that now this is the subsequent development, whether you're in a position now to abide by your offer. My lords, fair play.
You give me, you say that, can you get it from Sriram today?
Sriram with this, I can't say, but what he says is that he would be in a position to procure it from some other party.
So then it goes very much against the very tender condition.
That because that is why the tender required some identified manufacturer. I can see my lord free because government don't want to get it from. But my lord, there appears to be some element of solution between the R6, R7 and R5 and the government also this seems to be happy with that position. Some order from
You do one thing. I mean, Mr. Goswami, I think the best one will be you withdraw it for the time being, take it up with them. And then something can be done.
For future
I think
supply, because
future.
it is only.
Because this is what they have done. Problem is this.
This is the whole problem.
Because
why
if
we are
today, tomorrow you can again convince them to give it to you, then again they will change.
taking-
Or you do one thing, have it after vacation. In the
One of
meantime,
these
try
supply-
to
this part will be
persuade.
over because 30th
And this is only 367.
That is true.
You are an L1 bidder for 1500.
50 now.
And therefore I'm saying now this is
was not
more like a rate. They have fixed the rate at 35,100. And for the entire year, I suppose they have done it. How much they will be requiring will depend, will go on later on.
Lordship may then only issue notice and.
No, I don't issue notice like this. And this is not a case for a notice as of now. Next week I'm not sitting, so you may get a notice from some other court.
Then the court will say.
No, you are only taking into consideration 367 today. By the time when the matter, the case reopens, the court reopens, you may very well take it up.
Only thing for this part of the allotment, the last date is 30th December.
Huh?
Under the allotment order, the supply is to be done within 30th of December. So
But
this-
that is only, this is only 367.
Your lordship is right.
They may also go much beyond, they may purchase more than that.
Lordship.
Because that tender is not specifying how much. Is the tender specifying how much?
3,000
Then
have indicated the maximum.
Yes,
So,
Lordship.
so therefore,
I offered only
because
1,500.
when these rate contracts are there, it is always tentative. So after vacation, not now. You may get a notice from them. I'm not from me.
My lords, after vacation, they will say that it will become infructuous.
And it is only for this. I'll put it on record now
Then
that he has given this. So you may have to take a call on this, what is to be done. And therefore we put it up after vacation, what to do. Good stuff. Heard Mr. Goswami, the learned counsel appearing on behalf, senior counsel appearing on behalf of, assisted by Mr. B.P. Bora, appearing on behalf of the petitioner, and Mr. So-and-so, who appears on behalf of the Assam Seeds Corporation Limited. Mr. So-and-so appears for the Health, Irrigation, Agriculture Department of the Government of Assam. Good stuff. The petitioner herein is aggrieved by the action on the part of the respondent authorities to allocate only supply of 50 metric ton quintals of hybrid maize bio 605 to the petitioner out of the total quantity of 367 quintals, which the Assam Seeds Corporation is procuring. The counsel appearing, the learned senior counsel appearing on behalf of the petitioner submits that as the petitioner is the L1 bidder, the petitioner, unless and until the permissible quantity quoted for by the petitioner is not exhausted, the respondent, Assam Seeds Corporation respondent corporation cannot allocate. Where is that clause, Mr. Goswami? No, yeah. No, yeah. Cannot allocate to the other bidders. In that regard, he referred to clause 2.33.1 and 2.33.2 of the tender conditions. Mr. So-and-so, who represents the respondent, Assam Seed Corporation, submitted that though the petitioner had submitted the bid as a authorized dealer of Shriram Bioseeds Genetics and had submitted the undertaking in the form B4, but the said Shriram Bioseed Genetics have, by the letter dated 8/10/2025, informed the managing director of the Assam Seeds Corporation Limited that they have only authorized the petitioner for 50 quintals of hybrid maize, that's bio 605. In that regard, he has placed before this court the communication dated 8/10/2025, which is kept on record and marked with the letter X. Taking into account the above, Mr. So-and-so, Mr. Goswami, the learned senior counsel, submits that the petitioner would like to obtain instructions, list this matter again on 7/1/2026 for motion.
Item 9.
Lordship.
What is the matter?
Lordship, this is with regard to certain non-payment of bills. Lordship, there is already an arbitration clause in this contract. And
we have filed the affidavit today.
We have filed the affidavit today, Lordship.
You want to say anything?
Regarding arbitration clauses there, I've seen. Better maybe go to arbitration. Some dispute is also regarding bill also.
Do you agree? So easily.
As per client instruction, we want go for arbitration also.
Your client now wants to go for arbitration.
Yes.
Why didn't you say before filing of the affidavit?
No,
This is environmental degradation of filing so much big an affidavit. We'll have it after vacation.
Yes.
This is the matter after vacation on, was an affidavit in opposition has been filed by the respondent number 2 to 4. Full stop. Mr. So-and-so, who appears on behalf of the petitioners, submits that he would, that taking into account that the affidavit has been filed today, he would obtain instructions. List this matter again on 28/1/2026. Liberty is given to the petitioner to file reply, if any.
Obliged, Lordship.
Madam, Your Lordship, department is to file, the inspection, report, Your Lordship, verification report. Your Lordship.
Okay. Miss N. Bora, the learned Standing Council of the PNRD, pursuant to the order passed by this court dated 15/9/2025 and 5/12/2025, have placed an instruction issued by the Block Development Officer, Kalyan Development Block, dated 18/12/2025. The same is kept on record and marked with the letter Y. From a perusal of the said instruction, it is apparent that a notification has been issued constituting a block level scrutiny advisory cum monitoring committee under the Kalyan Development Block to redress and to frame guidelines, etc., for maintaining transparency in allotment of bids, eradicate illegal construction / occupancy, full stop. It is being submitted that some time may be granted to the said committee to take necessary action and place it before this court and place an update before this court. Taking into account the above, list this matter again on 9/3/2026. In the meantime, on the next day, the PNRD, the Block Development Officer, Kalyan Development Block, shall provide the update on the next. Yeah, Paul, what has happened? Oh, you are in this side? Huh?
Let me tell you, Your Lordship, as in page 97.
Instead, Miss Bora, who is to pay?
Lordship, Commissioner Panchayat and
Huh?
Commissioner Panchayat and Rural Development Department. So
No, how long this, we impose interest sum from 1999? What do you
let's
say, Mr. Upadhyay? Do you support interest? You don't want to say? Huh? Madam, you can't delay like this. This is an old matter. 12/11/2025, we have issued notice. Second round of litigation. Final, I've already given a final opportunity. So that means it's a case of cost.
Lordship, after vacation we will file.
When? He's asked for 2 weeks.
Lordship,
So during vacation, 2 weeks will be over. So on the date of reopening,
before Bihu vacation.
huh?
Before Bihu vacation.
Okay, Bihu. Before Bihu. I can't give you like this. Give me a good reason.
Okay.
We take the item as the last item. Think about it. What is the reason? Then let me put it because I have already said the final opportunity is given. So
Lordship,
under such circumstances,
already we have communicated, so they need 2 weeks time.
I can't give you now. It's already an order passed. So I'll be sitting over my order. I can't do that. So you, as a last item, think. Being the last day, think as a last item.
Lordship,
Wait. Don't go so early. Then you realize not filing an affidavit is.
So on 9th of December, we file our affidavit. Lordship.
You file, na?
While their affidavit, in the affidavit, they have stated that this person who has appeared before them, the petitioner here, can given a statement. In the statement, he said that the car is his, but the name in the address cannot be verified by either him, and therefore they have not released the car. This is basically the overall the gist of the matter. I mean, Lordship, I need to take some instructions and I'll, if required, I'll file a reply with that issue. Whether that new address which he has provided, whether he does have some address.
No, they categorically say, if I remember as looking into that affidavit as well as the order he has produced, that you have failed to produce the documents as regards the car, the vehicle in question. And something, I think this car is in Rajasthan or something, no?
Yes, his name, but the address is in Rajasthan.
Rajasthan, some
You-
Jodhpur. Jodhpur, na?
Jodhpur Commissioner in.
Ah, you have inquired with the
Yes, yes,
Jodhpur
Lord.
Commissioner. Yes, I remember. Yes.
The car is registered in
Rajasthan.
Rajasthan. That is I have seen that. I don't have any instruction as such. And that is.
There is no urgency. Why don't you go and file a Jimma petition against them at that time? Oh, anyways, we'll have it.
On date, your lordship, let me try, otherwise we'll go there.
Okay. The Mr. Y.S. Manan, the learned counsel appearing on behalf of the petitioner submits that he would obtain instructions from the petitioner in view of the stand taken by the respondents in the affidavit in opposition, and if necessary, file a reply. Full stop. List this matter when? Chalo. 4th of February 2026.
Obliged.
In the meantime, the reply be filed on or before 2nd of February. Yes, Miss Enbora.
File our affidavit.
You have filed?
Lordship,
It has been submitted that the affidavit has been filed on behalf of the PNRD department. Full stop. List this matter again on 16th of February 2026. What is happened? Oh,
In this matter, subsequently thereto on 13th, they have issued a notice under section 94 of BNSS, wherein I was directed to produce the required documents with regard to the car. And as per my instructions, please, we cannot file it because subsequent to the writ petition that was issued. we can't do it because the petition.
truck is in your position.
Yes, madam.
They are.
Huh?
In his possession, madam.
Your position.
The
Truck is in your possession, but you have not been allowed to pass through.
Yeah. This is the, I could not, this was on 13th, subsequent to filing of the writ petition. So I've got that. And this is the notice under section 94 of the laws. And we have in fact received these documents from Meghalaya, from Meghalaya also. And if it also requires, I can hand over.
Section 94 notice was issued upon you on 12/12.
Yes, we have received on 13th.
When did you file the writ petition?
That was filed on 11th. So this was subsequently received. I have a.
So what should we do now? We
They
can't
said
keep
that
this
these
matter.
documents have to be produced, and now we have already have these documents, Your Lordship. We would like to produce them, and they have given us 7 days time, so it will be expiring tomorrow. I don't know whether by today or tomorrow they might. And
So therefore-
this documents are already there. We have got this from the government of Meghalaya with regard to the royalty and the papers of
In pursuance to the directions passed by this court on 16/12/2025, Mr. M. Setia have placed before this court a set of documents along with the instructions which are collectively kept on record and marked with the letter X. From a perusal of the the instructions, it is seen that the petition driver of the vehicle in question was issued a notice under section 94 of the BNSS 2023 on 12/12/2025 to produce requisite documents. Full stop. Mr. Y.S. Manan, the learned counsel appearing on behalf of the petitioner, submits that in that 7 days period so granted expires only tomorrow. Tomorrow. And in the meantime, the petitioners are doing the needful. List this matter again on 7th and the 8th, 9th.
7, but till then, if they releases that.
That I will say on 9/1/2026. Full stop. It is observed that pending disposal of pending the next state, comma, it shall not be a bar on the part of the respondent authorities upon being satisfied consequent to verification to release the vehicle, to allow the vehicle of the petitioner to cross the borders of Assam.
If my lord-
Borders of Assam only, no? You are
Assam.
holding it at the border of Assam.
Yes, ma'am. If my lord documents are found to be correct, ma'am.
That is what's. No, I said that. What is that? Read it for Mr. M. Setia's better understanding.
With me also.
I am not going to look that. What is this?
Lordship, I'm appearing for the respondent number 4, Lordship. I pray for some time for filing my affidavit in opposition.
They have entered appearance. Don't we come up for admission hearing?
You have filed affidavit.
Lordship, we'll be praying for some time for filing affidavit.
You are paying for?
Respondent number 4.
Okay. The counsel appearing on behalf of the respondent number 4 seeks for some time to file affidavit in opposition. So the counsel for the petitioner also submits that he would file the affidavit in reply to the affidavit of the respondent number 3. List this matter on 4th of February 2026. In the meantime, the said pleadings be completed. Interim order passed earlier,
Yes, Lordship, interim order is there.
then extended to the next date. Give me last. Proceed. Very good. Yes, madam. The last item of the year. Give me a good reason.
Lordship, instructions not listed, so
That I understand. Give me a good reason what to write. I gave you a final opportunity.
2 weeks with file affidavit.
No, that I know, but how do I allow you? When I said, in the meantime, final opportunity is given. I've already committed myself. Then how do I permit?
Last chance may be given.
Last chance is last, final now, last is same. Tell me.
Lordship has observed. Final opportunity is given. Lordship. This was
Muslim. It is seen that by the order dated 10/12/2025, this court granted a final opportunity to the PNRD department to bring on record their stand by filing the affidavit. However, no affidavit has been filed, and 2 weeks' time has been sought for submission of the affidavit. Full stop. This court duly takes note of that this is the second round of litigation, isn't it?
Lord-
And the petitioners herein are fighting for an amount of rupees 8,39,251, which is due to the petitioner in the year 1999. The materials on record also suggest that the concerned authorities have also given due justification that the petitioner is entitled to the said amount. However, the respondent authorities have not released the same. Under such circumstances, this court fixes this matter for final disposal on 11th of February 2026. It is observed that if no affidavit in opposition is filed on or before 2nd of February 2026, it shall be presumed that the respondents herein do not want to contest the contents of the instant writ petition, and accordingly, this court shall, applying the principles of the doctrine of non-traverse, decide this instant proceedings on the basis of the materials on record. I gave you 4 weeks, but
That's,
if you don't file, then it is okay.
that's.
Okay, happy new year to all of you.